Yes, Lordship. Lordship, I have some personal problem because of my son. So I beg to mention some like item number 4,
Item 4. Okay,
7 to 22, Lordship.
7 to 20,
23, 7 to 23,
23,
34,
34.
35, 36.
There's no other CGC. Is there no other CGC?
There are other CCCs also, because the mirror is with me, so
Okay, 34.
34 and 35, this is 34, 35 and 36, this is part third.
Ah,
and 37, Lordship.
But part heard matter, we are supposed
Yes,
to.
Lordship, because I have some
My
personal
lord,
problem, so I,
Yeah, what do you say?
tomorrow, Lordship. Not
36, yes.
Tomorrow,
tomorrow. Today I have some, Lordship.
you'll be able to come tomorrow. Tomorrow we can take up this matter. We'll keep it.
Because it's a portrait,
All right. 35,
other than this thing, but the portrait I can, yes.
all right,
Lordship.
35, 36 to be listed tomorrow. At the request of Mr. Younger.
37.
Uh,
Huh?
35, 36, right? And then what
The
are the
other-
other matters below
Any other date, Lordship, any other date, next week or any other date?
the other matters? The other matter would be item number 4,
4,
7
7 to 23,
34.
34, and 37.
My lord, 37,
1 minute. Yes, 37. yes.
I am for the petitioner. This is income tax matter, your lordship, and this is dragging since 2022, your lordship. And it is a covered case, your lordship.
Friday,
Okay.
Friday,
Okay.
so 11 on Friday,
Tomorrow,
tomorrow,
yes, your lordship.
tomorrow,
Tomorrow, it is a very short matter, your lordship.
yes.
हो जाओ।
All right, item 35, 36, 37 tomorrow.
This one tomorrow?
It is income tax matter, very
By the
short, your
phone.
lordship.
You come prepared with all judgments.
Yes, your lordship, yes, your lordship.
Then
Yeah.
item number
Today.
4,
Govinda, Govinda.
then 7 to 23 and 34.
Lordship, I'm for the petitioner, item number 4.
Item number 4, yes,
Yes. Let the matter be listed after a week.
after a week.
Yes, and Lordship,
It will be next week or after a week?
after next week.
Right, we listed
I'm
after
missing
1 week.
37 also.
Lordship, in item 4, pleadings are completed. Let the matter be listed for hearing.
You are agreeing for an adjournment, we'll list it, you make the prayer after a week.
Okay, Lordship.
Right. If the pleadings are completed, why are you mentioning it today?
CGC,
He is only seeking accommodation for the day.
Lordship.
All right, after 1 week. Okay, did you get item 4 after 1 week? 7 to 23
Govinda.
and 34.
We mention for tomorrow, so you will make a mention.
We'll have it next week on a date to be fixed by the next week.
May I please, Lordship?
Yes.
Lordship, item 37, can it be taken up on next week?
Item 37, next week.
Yes, Lordship.
Your lordship, it is fixed tomorrow. your
Oh,
lordship.
that income tax.
Yes,
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 your
yes,
lordship.
Lordship.
It is
Yes,
small
what is the problem?
My senior SGTR,
We told him to come today.
yeah, he is going to do the matter today, however. as
In
he-
fact, Lordship, item 37, I am for the ministry.
Yes,
I am
yes.
not a necessary party also. So
No, no.
if the income tax are present, then it can be taken up also.
Yes, we'll record your presence, don't worry.
Yes, Lordship.
Then tomorrow, then today,
We'll take it up tomorrow, ask him to stay back today,
Okay, okay.
all right, tomorrow,
Yes, Lordship.
37.
Much obliged.
Much, Lordship. Very much, Lordship.
May I please, your lordship? Your lordship, I beg to mention item number 28, hearing item.
Just 1 minute, item 37. Income tax counsel is here. Is he present today? He is available today,
Lordship, he is connected through VC.
or through VC?
Yes, Lordship.
Then we can take it up.
yes, your lordship.
Then we can take it up.
Yes, your lordship.
Item 37, strike it out, then we'll take it up.
Hmm.
Please inform Mr. Younger what we'll take it up. We'll record his presence.
Much obliged.
Your lordship, I beg to mention item 42 on behalf of Exemption. Kindly list the matter after 3 weeks, lordship.
Item
Yes, in
40,
disposal.
for the request made on behalf of Mr. S. Temjin, matter stands adjourned, will be listed after 3 weeks.
Yeah, please, your lordship. Lordship, I beg to mention item number 28, lordship.
58.
Lordship, here, I'm here to receive instructions, lordship, so kindly grant me some time, lordship.
Item 28 at the request of Leonard Governor,
Lordship,
matter stands adjourned to be listed after 3 weeks, enabling them to file the counter affidavit.
lordship.
Are you for the petitioner?
Yes, yes.
Is there any objection?
No, lordship.
Counsel for the petitioner does not object to the prayer made.
Much
Right.
appreciated.
Lordship, I also beg to mention item number 26, Lordship, on behalf of LD Sanctum, Lordship.
26.
Kindly grant me
26. Who's for 26? Any counsel for petitioner? Have you taken consent of the petitioner? No? 26. Any objection? Or what is the matter?
This is the petitioner's husband died in harness. In
Oh, we'll
family.
take it up. We'll take it up. We'll take it up. You wait. Let the matter be called up. We'll see.
Lordship,
If you face any difficulty, we'll accommodate you.
Lordship.
Yes.
May I please, your lordship? I beg to mention item number 29.
Yes.
With the prior consent from the other side, your lordship may kindly grant me 2 weeks time to file my affidavit. I'm for private respondent number 4.
Yes. Any objection?
No, your Lordship.
You are Mr.
James Newmy, sir.
Mr. James Newmy, learned counsel appearing for respondent.
Private respondent number 4.
Respondent 4, praise 4 and is granted 3 weeks time to file counter affidavit. Prayer made is not objected to by the counsel for the petitioner. Next
Sure.
after 3 weeks.
Your Mr. Lordship. Lordship, I beg to mention item number 39, Lordship, on behalf of Pichano, Lordship. If this matter can be passed over for the day, Lordship.
Who is the counsel for petitioner?
Lordship,
Any objection?
no objection, Lordship. Lordship, a short date may be given, Lordship.
See, either you object or you don't object.
Lordship, on Monday, it was fixed for today, but so
We can take it up tomorrow if you want.
Yes, Lordship.
Tomorrow.
Yes, tomorrow, Lordship.
All right, item 39 at the request of learned government advocate, matter stands adjourned for the day, passed over for the day to be called up tomorrow.
Okay.
Registry to list the matter tomorrow.
Lordship, if I may be allowed to mention item number 31, Lordship. On behalf of Avitoli, if 3 weeks time may be granted to file my,
Why?
I'm yet to file my counter affidavit, Lordship.
Who's for the petitioner? Where's, which item you're mentioning?
31,
31 or 27?
31, Lordship.
31. You are for the respondent.
Lordship, for the state respondents.
Yes, who's for the petitioner?
Lordship, I may brief for the petitioner.
Any objection?
No, Lordship.
Item 31 at the request of learned so-and-so government advocate. Matter stands adjourned for 3 weeks. Counsel for the petitioner does not object to the prayer made.
Lordship, I have similar prayer for item 32, Lordship.
Yes, who's for the petitioner?
Lordship, I may brief for that.
Right, same prayer, same order.
Much obliged.
Obliged, Lordship.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item 33. I'm for the respondent number 2, 3, 4, and 5. Lordship, may kindly enjoin the matter for today and
That's an income tax.
yes, lordship.
Why?
We will be filing our affidavit in opposition,
We means,
income tax.
what
lordship.
is the matter about?
The
You
matter
wait,
is-
you wait for the matter to be called up.
Okay, much.
My pleasure, Lordship. Lordship, I beg to mention item number 40,
Yes,
hearing item. I pray that this matter be kindly be listed after 2 weeks, Lordship.
you are for the petitioner.
Lordship,
Item 40, at the request of the counsel for the petitioner, matter stands adjourned to be listed after 2 weeks. No objection is raised by the respondents to the prayer made by the petitioner.
May I please, Lordship? Lordship, I believe item number 27 has been mistakenly mentioned by Mr. Gauhati. 27th,
Don't mention.
not mentioned, Lordship. In that
Item
case,
27 is not mentioned.
May I please, Lordship? Lordship, I beg to mention item number 30, Lordship. On behalf of Avitoli, Lordship. Kindly grant me 2 weeks time to file my counter, Lordship.
Item
30th, 30,
30.
30, Lordship.
Who's for the petitioner?
Yes, Lordship.
Any
I'm for the
objection?
petitioner. No objection, Your Lordship.
Item 30, at the request of government advocate, matter stands deferred. to be listed after 2 weeks.
3 weeks, Lordship.
3 weeks. Prayer made is not objected to by the council for the petitioner. Yes, list accordingly.
Much obliged, Lordship.
May I please, my lord. Lordship, I beg to mention item number 24, Lordship. For, I'm mentioning on behalf of MS Esmere. She's in bereavement today. She's for response. So if the matter may be listed next Tuesday, my lords can accommodate.
Next Tuesday, how many matters?
Three hearing matters and one motion.
All right. And the request made by Mr.
Yeah, my lordship.
K. Angami on behalf of Mr. S. Mary.
MS
MS
Esmere.
S. Mary, learned government advocate.
Lordship.
That the learned government advocate is in bereavement. A prayer is made for seeking adjournment to have the matter fixed on 12th of November. Counsel for the petitioner does not object to prayer made. Accordingly, let the matter be listed on 12th November for admission. Yes.
Pleasure, Lordship. Lordship, item number 5, Lordship. This is on my own behalf, Lordship. Lordship, I have taken the concern of the petitioner. If I may be allowed 1 week time to file additional affidavit, Lordship.
You're for the petitioner. You're for the petitioner.
No, Lordship, I'm for state respondents, Lordship.
Okay. You want to file additional evidence?
Lordship.
Yes,
No objection, your lordship.
no objection.
Yes.
You're the counsel for petitioner in item 5.
Yes, item number 5, yes, your lordship.
All right, Mr. K. Angami.
Lordship.
Learned counsel appearing on behalf of the government respondent.
Lordship.
Prays for 2 weeks' time to file additional affidavit. Prayer made is not objected to list after 2 weeks.
Pleasure, Lordship.
Yes.
May I bless your lordship. I'm appearing on behalf of my senior, Mr. Supongwati. I beg to mention item number 25. Your lordship, I pray I may be granted 3 weeks to file affidavit in reply.
25.
Yes, your lordship.
Item 25, your name,
Sikmo.
Ms. Mo, appearing on behalf of Mr. Supongwati Waling. Prays for 3 weeks' time to file additional affidavit in reply.
Yes, your lordship.
Affidavit in reply. Prayer made is not objected to by the council appearing for the state. Matter stands adjourned to be listed after 3 weeks.
Much obliged, your lordship.
Yes.
For motion, item number 1.
Yes.
May I plead, your lordship? Your lordship, in the instant matter, the petitioner is a substitute graduate teacher who is working in government middle school under the establishment of Sub-Divisional Education Officer LTO Kifri, that is respondent number 5. Your lordship, in the instant matter, the brief background is that there was one person, namely Sri Tongpang Ao Nok. He was serving under the same school as a graduate teacher, but on ad hoc basis. But since there was a disciplinary proceeding from the department, and during that period of time, he was placed under suspension. So during that period of time, the petitioner had applied for that particular post, and accordingly, the petitioner was appointed as a substitute teacher on behalf of Sri Tongpang Ao Nok. Your lordship, after the serving of 3 years as a substitute graduate teacher,
What is your prayer?
your lordship, there are many prayers, but especially I am stressing on clause 3 of my prayer. That is, since now this particular Tongpang Ao Nok has been terminated from the service, now I'm discharging the same similar duty which he was discharging. So on the principle of equal pay for equal work, I'm praying. My special prayer is that.
Are you appointed through regular process?
No, your lordship.
Then,
Your lordship, as a substitute teacher.
so, is it your case that other substitute teachers, your pay is not in parity with other substitute teachers? Is that one of your prayer?
With other ad hoc employees.
other ad hoc employees?
Yes, your lordship.
What is the pay scale that they're getting?
As of now, it is not in my knowledge, but whatever the petitioner has told me that above 30,000, but as of now, I'm only getting 8,400 rupees per month.
But your claim for regularization in the prayer is not maintainable because you're not.
Yes, definitely, your lordship.
So you're not pressing that prayer.
Yes, lordship.
Alright.
Only the close three of my prayer, your lordship.
Yes, who's for the respondent? What do you say? Is there a scheme for grant of minimum scale of pay in Nagaland?
As far as my knowledge is concerned, no, lordship. Yes.
No,
No.
there's a Supreme Court judgment saying you have to grant minimum scale of pay, even for ad hoc and temporary workers.
Lordship.
You get your instructions here.
Lordship.
Is it necessary to issue a notice?
Lordship, in that case, notice may kindly be issued, lordship.
Heard, Mr.
P. Suril, lordship.
P. Suren, learned counsel appearing for the petitioner. Also heard Mr. K. Angami, learned government advocate,
Lordship, senior government.
senior government advocate. This writ petition is filed by the petitioner who claims to be an ad hoc teacher serving, who claims to be a teacher serving as a substitute graduate teacher in government middle school under the establishment of subdivisional education officer Kipriye at Changchor village in the district of Kipriye, Nagaland. So she joined in her services with effect from 2402 to 2012 and has been rendering continuous service as a substitute graduate teacher without any break. Stop. The writ petitioner was appointed as a substitute graduate teacher in place of one Tongpang Anok, para 3. You can check out the name in para 3, who was also serving as a graduate teacher in the same middle school in the same district, same village in the same district. Stop. Pursuant to a proceedings initiated against Sri Anok, he was placed under suspension and the petitioner was having applied for, was appointed to the post of graduate teacher and she was allowed to work as substitute graduate teacher. Stop. Subsequently, pursuant to the proceedings initiated against Mr. Anok, his services were terminated. Stop. However, the petitioner continued to render her services as substitute graduate teacher. Under such circumstances, the petitioner submits that her case should have been considered for regularization as well as pay for as well as grant of regular scale of pay. Several representations made before the authorities have had invoked no response. Stop. Left with no alternative, the petitioner is before this court praying for writ direction or an order to the respondents. Stop. The petitioner in the writ petition has prayed for a direction to regularize the petitioner in the post of graduate teacher in which she is serving as substitute graduate teacher. And also for grant of the pay scale at regular scale of pay as is payable to other ad hoc employees. So after submitting for some time, learned counsel for the petitioner fairly submits that the prayer made in the writ petition seeking regularization of the petitioner in the in the post of graduate teacher in which she is rendering her services as substitute graduate teacher is not pressed and no prayers are made to that effect, nor any orders are called for from this court. Stop. His prayer at the present is only with regard to grant of regular scale of pay at par with other ad hoc employees of the state and slash the department rendering such services. Where, having heard learned counsels, then you write, learned government advocate submits that he be granted some time to complete his instructions in the matter. Where having heard learned counsels for the parties, let notice issue returnable 4 weeks. The respondents having been represented by Mr. K. Angami, appearing on behalf of respondents 1, 2, 3, 4, 5. Notices are waived, however, extra copies be furnished within 1 week from today. Sufficient extra copies be furnished within 1 week from today. Steps on respondent number 6 by usual course and registered post within 1 week from today. Let the matter be listed after the returnable date. Stop, the respondents are at liberty to file their objections, affidavit in the meantime, if so advised.
For motion item number 2.
May I
Yes.
please your lordship? Lordship, here the petitioner is seeking for the release of the placement errors that is due to him. In terms of notification 27/10/2021, lordship.
Where's the notification?
Notification is at page 20, lordship, annexure C.
This is a 22 notification.
Lordship, it's at my apologies, lordship. Annexure C, yes, lordship. 39/2022, lordship. Lordship, the relevant page, the serial number of the present petitioner, lordship, is at page 26, lordship. Lordship. At the serial number 14, if the last portion, lordship, the last para. That is serial number 14, Zinoboto, Government College, Zinoboto, lordship. The name of the petitioner is at serial number 1, lordship.
That amount you have not got.
Lordship, yes, lordship. The gross amount, that is 30,55,075 rupees, lordship.
No, but the amount to be credited, that is to be credited to the
Lordship.
GPF.
Yes, lordship.
That has been credited.
No, lordship, that is yet to be received, lordship. This is the amount that is yet to get, lordship.
Who's for the respondent? What do you submit?
Lordship, the notice may be issued at this stage, my lord.
Heard,
Mika Aitaya, lordship.
learned counsel appearing for the petitioner. The also heard Mr.
N. Angami, lordship.
Angami, learned government advocate, appearing for the state. Petitioner before the court is a former principal of the Wang Khao College in the district of Mon, who superannuated with effect from 17/7/2023. Stop. The petitioner before the court is claiming benefits in connection to, in respect of a government notification. Where is that notification again?
My lord, that's page 20, lordship. It's a letter, lordship. My sincere apologies. Annexure C.
Communication, you write, government communication dated 39.
Lordship.
Is it?
39/2022, lordship.
39/2022, within bracket annex C, whereby it was informed that the government of Nagaland had issued order for placement of assistant slash associate professor slash librarian ID orders dated 27th of October 2021. And accordingly, AG Nagaland has issued their pay slip. Placement area accumulating pay slip full stop, placement areas accumulating to rupees 24 crores 50 lakhs 18,097 have been sanctioned. Stop. Referring to the enclosures to the state communication, learned counsel has pointed out. Where is that name?
Lordship, page 26, Lordship.
In respect of the Junepoto Government College in Junepoto, the name of the petitioner is shown to be entitled to a gross amount of rupees 3055,075. Stop. Learned counsel for the petitioner submits that in spite of the communication dated, the communication issue and the sanction by the AG Nagaland, the amount mentioned has not been sanctioned to the petitioner. And meanwhile, the petitioner had already superannuated with effect from 17/7/2023. Being agreed, the present writ petition is filed. Where Mr.
Nangami, Your
N.
Honor.
The Nagaman advocate submits that the notice at this stage be issued, permitting him to complete his instructions. Where let notice issue returnable 4 weeks. Mr. Rangami appears for respondents.
All the respondents,
all
Your
the
Lordship.
respondents. And as such, formal notice be waived. However, sufficient extra copies be furnished within a period of 1 week from today. Matter be listed after returnable date.
My lord, I also have a prayer.
Pendency of the writ petition shall not be a bar to release the dues payable, found payable to the government. Yeah.
Lordship, there is a similar matter that is also pending before this court, Lordship. So if that WPC can be listed along with this matter.
When is that matter fixed?
It was yesterday, Lordship.
When is it coming up?
After 2 weeks, Lordship. It's coming after 2 weeks.
Let the.
Let the matter be
let the
listed, Your Lordship,
returnable-
yes.
When that matter
Yes.
gets listed, you make a mention to be listed along.
Correct, madam.
Lordship, much obliged, Lordship.
Deeply obliged, madam.
For motion item number 3.
May I please, Your Lordship?
Yes.
Lordship, the petitioner herein is praying for compassionate appointment. In terms of OM dated 17/9/2015 in the Department of NPWT.
Where is that? When?
It's at page 19 in Exterior C, my lord. Operative portion is at paragraph 4, my lord.
So kindly take us through this. Where does it, what does it say?
Lordship, the main objective of this scheme is to provide immediate assistance to the family members of the deceased government servant who died in harness while serving the department,
So
Your Lordship.
who died? The husband,
Your Lordship, the mother of the petitioner.
mother of the petition. Then did you represent before the authority?
Yes, Your Lordship. By letter dated 8/6/2021 and 25/6/2024.
Then
However,
what has happened?
However, the application submitted by the petitioner was left unattended.
Unattended?
So, yes, Your Lordship. So being aggrieved, the petitioner is filing this instant petition. Your Lordship, the first application is at page 21 in Exterior D. And the second one is at next page, page 22.
Yes, who's for the respondent?
Lordship, let notice go, Lordship.
Oh, I notice his prayer is that these applications has not been
Or Lordship, we can,
attended. We'll dispose it of
Yeah.
the direction to dispose of, look into the grievances and pass appropriate orders in terms of the notification.
it's part of your
Yes.
end, Lordship.
Yes,
Within a time bound period.
Lordship,
Okay. Heard? Yes, sir,
Mr. Kajishi, Lordship.
come again.
Mr. Kajishi, Lordship.
Mr. Kaji Singh. Learned counsel appearing for the petitioner also heard MS
S. Chang.
S. Chang for the government advocate appearing for the, you are appearing for BWD also?
Lordship, for all the response, Lordship.
All the respondents. This writ petition is filed by the petitioner, praying for consideration, praying for appointment on compassionate scheme. In terms of as per the compassionate appointment policy of the government of Nagaland, notified by OM number so and so dated 17th September 2015. It is submitted by the counsel for the petitioner that the mother of the petitioner, where is the death certificate?
Is it annexed here at page 17?
Mother of the
Page 13, my lord, annexed here A.
Tiakala expired on 2/6/2021 while she was employed under what?
NPWD Kohima.
NPWD Kohima. Stop. The mother of the petitioner, she was working as?
UDA lordship.
Was working as a UDA.
UDA Mechanical Division,
In the UDA Mechanical Division.
2, Roman 2, Kohima. Page 17, his name is figure at serial number 9, your lordship. Page 17, annexed here A2.
Okay.
Serial number 9, your lordship.
The initial appointment order is at page 14.
Yes, lordship.
Was working in.
First, he was appointed as LDA, lordship.
Yes.
Thereafter, he was promoted to UDA. By order
Working in
that
the NPWD Kohima. Learned counsel for the petitioner submits that the petitioner, being the daughter of late so and so, applied for being considered for appointment, applied for an appointment under compassionate scheme, as the mother of the petitioner was the sole bread earner of the family. So, however, repeated applications and requests made by the petitioner have remained unattended. And no steps have been taken towards appointment of the petitioner. Consequently, the petitioner is before this court, praying for a writ direction or order to the respondents to appoint the petitioner in any suitable post under the compassionate scheme. Learned government advocate appearing before the court submits that she has no instructions in the matter and therefore submits that she be permitted to obtain instructions thereafter. After hearing the counsels for the parties and upon careful perusal of the writ petition, it is seen that the prayers made in the writ petition are for direction to the respondents to consider the petitioner for appointment in compassionate ground in terms of OM dated 17/9/2015. Stop. The further prayer is to consider the petitioner for appointment in compassionate ground in any available regular vacancy as per. It is his or her.
Her, your lordship.
Her educational qualification. Stop. Considering the limited prayer made in the writ petition, this court is of the view that this writ petition can be disposed of at this stage, since the representations have already been made by the petitioner for considering her case for being appointed under the compassionate scheme in any suitable post. From the writ petition, it is seen that the petitioner's mother was initially appointed in the post of lower divisional assistant within Bracket district under the Nagaland Public Works Department by order dated 26th of April 2007. In the list of appointees, the name of the mother of the petitioner is found at serial number 74, and she's shown to be posted in mechanical engineering -2 Kohima, within bracket ME-2 Kohima. So subsequently, she was confirmed in the services or as UDA district in mechanical engineering, PWD, mechanical division -2 Kohima, in which post she continued to render her services till her demise on 9/6/2024. Where is the death certificate?
Next year, page 13, Your Lordship.
And what is page 18?
Page 18 is the death certificate of her father, Your Lordship.
Her
Father, Your Lordship.
father.
Yes, Lordship.
How is it relevant?
Your Lordship, since she's an orphan, Your Lordship,
Okay, the petitioner's father.
yes, Lordship,
All right.
the petitioner's mother as well as
All
his father.
The death certificate relating to the death of the petitioner's mother is enclosed as Annexure A. The certificate is issued by the Department of Economics and Statistics, Government of Nagaland, dated 8/6/2021, which certifies that the late mother of the petitioner, C. Tiakala, expired on 2/6/2021. Stop. The writ petition further contains the death certificate of the father of the petitioner who expired on 9/6/2024, and a certificate to that effect issued by the concerned department dated 2006/2024 is also enclosed. The petitioner is about 25 years old, and she's a graduate,
Yes, Lordship.
and is a
In the-
graduate in political science from the University of Delhi. So the state of Nagaland, by the office memorandum number so and so dated 17th September 2015, has notified the revised compassionate appointment scheme for the state government employees who die in harness. So under this scheme, it is provided that appointment on compassionate grounds shall be given to the following members, namely number 1, number A, spouse, number B, son, number C, daughter. So the appointments, paragraph, the appointments on the compassionate grounds made under the scheme shall be only on regular basis to direct recruit posts, and only if regular vacancies meant for that purpose are available in the department. So the scheme provides for the procedure and as to how the applicants are to be considered and appointed under the compassionate appointment scheme. So the petitioner had also represented before the the engineer in chief
Engineer.
PWD, Nagaland, praying for compassionate appointment in the post of UDA on account of the death of her mother. Stop. The said application was submitted on 8/6/2021. The same was is seen to be accepted and proper endorsements by appropriate authorities are made recommending appointment on humanitarian grounds. Stop. The subsequent application has been made again on 25/6/2024. Stop. Which was also duly received in the office of the Engineer in Chief, Nagaland, PWD Kohima. Stop. It is the case of the petitioner that in spite of the applications made before the appropriate authority, the authorities have not intimated as to what steps have been taken towards the prayer made by the petitioner for her appointment in the under the compassionate scheme in terms of the office memorandum number so and so dated 17th September 2015. So the under such circumstances, this court is of the view that the writ petition can be closed at this stage without issuing notice, directing the respondents, more particularly the respondent number, who is to pass the order? Respondent 2.
Respondent number 3, Lordship.
Three, Lordship.
The respondent number 3 to no, but who is going to pass the orders? I think it is Commissioner and Secretary. Respondent number 2 and 3 to take necessary steps in the matter and consider the applications made by the petitioner and pass appropriate orders thereon. Stop. If the petitioner is found to be eligible for being considered for appointment under the compassionate scheme as notified by the government by the office memorandum number so and so dated 17th September 2015, the competent authorities will pass necessary orders without further delay. Stop. Any orders as may be passed on these applications by the authorities, a copy thereof shall be served on the writ petitioner without fail. Stop. This direction of the court be carried out by the respondent authorities within a period of 4 weeks from the date of receipt of the certified copy.
Lordship, 2 months at least, Lordship.
All right, 8 weeks, 60 days. 60 days from the date of receipt of a certified copy to be served by the petitioner.
Yes, Lordship.
Stop. Or we do it like this, 60 days from today. 60 days from today. Stop. If the authorities find that the petitioner is eligible to be considered for appointment, regular appointment under the compassionate scheme, then consequential orders be passed without further delay. Writ petition accordingly stands disposed of. In terms of the above, no order is to post.
Obliged, Lordship.
For admission, item number 6.
Lordship, the counsel for the private respondent seems to have taken leave. Otherwise, it was.
You don't want to file a reply? Reply affidavit?
No, your lordship, it's, the record speaks otherwise, so based on the record, I'm going to submit, your lordship. I have filed one additional affidavit also.
What is the issue here?
The petitioner is the owner of the land on which the department has established an office. So he was claiming for appointment on land ownership basis when the private respondent was appointed. Now it so happened that the private respondent, prior to his appointment in this particular case, had availed another appointment in some office, which came to light only recently. So I have filed one additional affidavit that he has, when he was appointed, he had already been appointed to another post. So the second appointment.
Is it, what does the affidavit say?
The affidavit filed by the private respondent, your
By
lordship.
the government?
Even the government department doesn't seem to be aware of the appointment of the private respondent in another office. It's another department.
Where is your additional affidavit? What do you say there?
The additional affidavit is, which date is this? Yes. Filed on 38/2024, your lordship.
Who is the private respondent? What is the name?
His name is
Hakchomong Sangtam.
yes. Hotingsi,
No,
it should be Hotingsi Sangtam.
Tingsi.
Hotingsi Sangtam.
No, your additional affidavit
Yes,
says that some appointment was made
yes.
on the basis of land ownership. Page number is annexure 1 to your additional affidavit.
Yes.
So see the communication dated 3rd of March. 3rd March. You have that?
Your lordship, no.
No, your additional, whose
Yes.
additional affidavit?
Yes, yes, yes.
Additional affidavit filed on 26th
Yes,
of June. Is filed by T. Chaubi Thongar.
yes, your
You are
lordship.
the petitioner.
Yes, I'm the petitioner.
Right. You come to that affidavit
Yes.
at page annexure 1.
Annexure 1, page 4.
Yes.
Yes, this is the private respondent in the instant case.
No, but that's not the private. I think it's his father. Is it?
No.
Serial number 3? It says late Intichuba Sangpa.
No. Shri Hotingsi Sangtam, your lordship, annexure 1. Shri, the appointment order is in respect of the private respondent only, your lordship. That is,
I don't know, this affidavit is filed on 26th of June.
no, ours is filed on 30th of August, 2024, your lordship.
Okay, 30th of.
30th of, this is an additional affidavit. Annexure 1, page 4, Your Worship.
So who is Hotensi?
Hotingsi is the private respondent in the present case.
Okay.
Prior to his present appointment, he was already appointed.
He's holding two posts.
He is. He was already appointed in one post as per his appointment order.
You get
And-
instructions on this?
Lordship, I'm appearing on behalf of my colleague, Lordship.
Who's your colleague?
Avitoli, Lordship,
You're a government advocate.
Lordship,
Are you a government advocate?
Lordship.
Then you are competent. Your colleague is not here, you are there.
Lordship, if this matter can be listed next week, Lordship.
Yes, we'll list it next week, but you get the instructions that we want. Do you have a copy of this affidavit with you?
No, Lordship,
No brief.
no brief.
Oh. What has happened to the brief?
I'm not in this matter, Lordship.
How will you inform your colleague?
Only inform her, Lordship.
Is she coming tomorrow? Is he or she?
She,
She
Lordship.
is coming tomorrow,
She'll be coming next week, Lordship.
next week. But
Lord.
next week, if you wait to get the instructions, we'll not be able to complete the matter. If a person is already holding a post, where is the question of asking for another appointment?
I'll inform her, Lordship, so that she can get some instructions, Lordship.
Do you have, Mr. Ponger, you have a copy of the affidavit? Additional, extra copy?
I can provide her
You
with
furnish
one
her
copy.
one copy and mark it. You get the instructions, we'll keep it on Tuesday,
Thursday, Lordship.
Thursday. Okay, Thursday, how many matters are there?
Copies are there, pages.
Only 1 minute.
No.
Do you have a copy? Give her a copy. Third. The council's appearing copy. It is pointed out by Mr. Tongpok. Mr. Pongier, that an additional affidavit was filed on 31st of August, 2024. In which an office order dated 11 November 2022 is enclosed, issued by the Chief Engineer PHED Sanitation and WSSO Nagaland Kohima. Stop. As per the said order, Sri Hotengshe, son of Sri Thikri Yesu of Chare village, Chuengsang, is shown to be appointed as operation and maintenance staff. Stop. It is submitted by the learned counsel for the petitioner that the present private respondent number
5.
5. 5. Private respondent number 5 is already holding a valid appointment in a government department as per the said application, as per the said order dated 11 November 2022. Under such circumstances, there is no question of the private respondent being appointed again
Yes.
in another government post as what?
As full attendant.
Full
Full attendant, yes.
attendant under the veterinary department.
Yes.
So in view of the additional affidavit filed on 31st of August 2024, which is brought, in which the order dated 11th November 2022 purportedly issued, showing the appointment of the private respondent is enclosed, Kumar. Learned government advocate appearing before the court today is permitted to obtain an instruction as to whether the submission, whether the contentions of the counsel for the petitioner in respect of the private respondent holding 2 government posts at the same time is a correct information. So let the matter be listed again on
Thursday.
Thursday.
Thursday, Lordship.
Your Worship.
Right, Thursday, it will be 14th November. the learned counsel for the petitioner is permitted to furnish extra copy of the additional affidavit to the learned government advocate to in order to enable her to obtain the required information as directed by the court.
Your Lordship, there is an interim, Your Lordship.
Interim order, if any, will continue until further orders.
Your Lordship.
Interim order is like.
For admission, item number 26.
My lord, the petitioner husband, he was appointed by annexure one. No, annexure one, he is a trained carpenter in this Sony furniture house, Kohima. To that effect, a certificate was given.
What is your prayer?
My prayer is that the petitioner, who is the wife, should be paid the family pension,
Family pension.
my lord.
There is no affidavit filed by the government.
No,
That will be required. Who is appearing for the government in this matter?
26.
Yes, government advocate, who's there?
I received the instruction recently.
Okay.
May I pray that in a week's time may be allowed to find my.
Can we keep it next week?
Yes, ma'am.
Like then we'll post it on Thursday.
Yes, ma'am.
7/12.
You'll be able to file the affidavit by then?
I'll be sending for waiting also. So if granted a 2 weeks time maybe.
All right. Yes, he says instructions are received.
My lord, has no objection. In Muzri also is appearing for accountant general, R8.
Okay. Have they filed anything? No.
No. My lord, actually what happened is this. After the death of the husband, the petitioner represented to the government. It was endorsed by the minister in charge. So accordingly, posthumous regularization was given. And after that, when the pension was put up to the AG says that no, you have to get the approval of this or that thing. When the regularization was done by the competent authority, that is engineer in chief. So AG is a very important party.
Where is the counsel for AG?
Yes, ma'am.
Where is he?
In Mozui.
All right, heard learned counsel with the petitioner, also heard learned additional.
LD Samdam.
Your misters?
LD Samdam.
LD Sangam, learned additional AD appearing for the respondents. State of Nagaland. Mr. Sankam submits that he has received instructions and prays for 2 weeks' time.
Yes, ma'am.
To file an affidavit in this matter. Stop. Let the matter be listed after 2 weeks. Yes, let it come after 2 weeks.
My lord.
Much.
For admission, item number 27.
Yes.
May I please, Your Lordship?
Yes.
Lordship, in this matter, perhaps the respondent counsel is not present today.
Who is the respondent counsel?
This is a specially engaged counsel for the Department of Goods and Service Tax, GST department.
Appearing here.
Lordship, the respondent counsel is one AK.
AK Misra.
He's from Dimapur, I mean Kohima.
No, he's from Assam.
You inform him, we'll take it up on Monday. Are the pleadings completed?
Pleadings are complete, Lord.
Pleadings are complete. Then the council.
Yes, complete.
Is his name not reflected in the cause list?
No, Your Lordship.
No. All right, we'll have it on Monday. Mr.
Lordship.
Todi, please attempt to inform the council concerned.
I'll inform Lordship.
Heard Mr. A. Todi, learned counsel for the petitioner. The respondent goods and service taxes is represented by Mr.
A.K. Mishra.
A.K. Mishra.
A.K. Mishra. It is submitted that the respondent goods and services is represented by A.K. Mishra. However, the council is not present for today. The cause list also does not reflect his name. The court therefore considers it appropriate to defer the matter today to be listed on Monday, which is on 11th. Stop. The registry will take steps. The registry will reflect the name of Mr. A.K. Mishra, Standing Counsel, Goods and Service Taxes Department, Nagaland, in the cause list. Stop. The petitioner counsel is also requested to intimate the counsel or the respondent about the order today. Let it come on Monday.
Lordship. And there is an interim order, Lordship, which is till today can be continued.
Interim order continued, interim order passed earlier, if any, will continue till the next day fixed.
Much obliged.
There is no other government counsel available here?
No, Lordship.
Mr. Additional AG, Mr. Santam? There's no government advocate available here for these matters?
My lord.
Goods and service taxes matters and all.
In fact, Lordship, respondent 1, 2, and 3, they're represented by Mr. A.K. Mishra.
Mishra.
Yes. All the respondents. Since it's a central goods and service tax.
But they have a commissionerate in Dimapur.
Yes, yes. The commission to
My lord, state is not involved.
State is not party here, Lordship.
Not the party.
No, but there's the state goods and service tax.
No, it's central, Lordship.
No, central goods and service.
Central. Okay. Okay. On Monday.
Lordship.
Much obliged.
For orders, item number 33.
May I please, Your Lord?
Yes.
My lord, I am appearing for respondent number 2 to 5 in this case, my lord.
You're not visible.
My lord.
You are not visible. We can't see you.
There may be some technical errors, my lord. Otherwise, I am connecting with my camera, my lord.
We don't know, but you are not visible. We can't see you. We don't know who is appearing on behalf of the standing council unless we see.
Lordship, I am trying, my lord, some technical glitch.
Well, if it doesn't work, then you have to be present physically.
Lord.
Yes. Yes. What is the matter about?
My lord, Lordship, they are challenging the order of assessment.
You are for the petitioner or respondent?
I am for the respondent number 2 to 5, my lord, Income Tax Department. My lord.
The petitioner.
Your Lordship, I am appearing on the instruction of my senior. Kindly refix the matter since she's in this post.
Refix when?
Next week.
Next week.
2 weeks.
2.
What 3 weeks?
Lordship, in this case, we are going to file affidavit in opposition.
First, tell us what is the matter about. Yes, Mr. Sekia, tell us.
Yes, my lord, they have challenged the assessment order, my lord, dated, my lord, Lordship, the assessment order dated 31/3/2022, my lord. That is for assessment year 2015 and 16, my lord.
No, why? They have challenged this order. This order is passed under what provision?
That is, my lord, under section 147, my lord. 148 notice was issued, my lord. Thereafter, my lord, they passed the order under 147, my lord.
147, 148.
Lordship.
Yes.
And in fact, my lord, they have filed an appeal, my lord, before the appellate authority, my lord.
Hmm.
That appeal, your lordship will find it page 67, annexure 9, my lord.
Appeal against this order.
Lordship.
No, but where is your notice for one under 148?
Yes, lordship. Your lordship will find the notice, my lord, at page, lordship, 46, my lord, annexure 4, my lord.
Forty-six.
Lordship.
So
It
this
is
is
tabled, my lord.
the assessment, which is at page 47.
My lord.
And the page 47 order, already an appeal has been filed.
Lordship, lordship.
But you are seeking to reopen this assessment.
Lordship, against this order only, they have filed appeal, my lord.
Against this order.
Lordship.
But is an appeal maintainable there?
And that's the issue, lordship. Since they have filed an appeal, my lord, that has been pending.
Whether an appeal is maintainable against a notice under 148, you have not commenced proceedings. I mean, you have not passed any order under 147.
Lordship, we passed the order. That is, lordship, at page, my lord, we'll find it page 47, my lord. This is the assessment order, my lord.
No, this is the assessment order under pursuant to the notice of 148.
My lord, my lord.
No, I don't think that is a correct view.
Look, in fact, my lord, we received the parawise comments, my lord. We like to file our affidavit, my lord, detailed affidavit, lordship. Some time may be granted, my lord.
You should have filed it. Because there is an interim order.
Lordship, lordship.
Who's for the petitioner? Who's the counsel for the petitioner?
Nityo Kozar.
Her matters, I think, are fixed on Monday. We'll take it up on Monday. Let's find out in our presence. Right, Mr. Setia?
Lordship.
We'd like to have you here on Monday.
My lord, my lord.
Physically.
Lordship, I'll try to come.
All right. Okay, list this matter on Monday as a request has been made by, in behalf of the counsel for the petitioner, that the petitioner counsel is indisposed today. Mr. S. Setia, Leonard Senior Standing Counsel for Income Tax Department, assisted by Mr.
K. Nagi.
K. Nagi.
Yes, Lordship.
Mr. Setia appears before the court through BC, whereas Mr. Nagi is present before the court.
Your Lordship, there is an interim order. Kindly let it
The
continue.
interim order passed will continue till Monday. Please inform her that the matter is fixed on Monday.
Much obliged.
Obliged.
For hearing, item number 37.
$37. Yes.
May it please your lordship. This is I'm aggrieved against assessment made by the Income Tax Department, your lordship. Your lordship, I hail from a Kyamungan Naga tribe, which is recognized as scheduled tribe under the constitution. This 3625, it covers 342 article. Now, your lordship, I was ex-government employee. After retirement, I started my business that procuring rice, paddy, etc., your lordship. And I used to dispose it to interior parts and other parts within the state of Nagaland, Your Lordship. Now, Your Lordship, I was having out of my past savings, Your Lordship, and out of my income derived, I kept some fixed deposit in Dimapur within the state of Nagaland. And from where I derived this interest on securities. But I am exempted under Section 1026 of Indian Income Tax Act, being a Naga. And since I am doing my activities within the state of Nagaland, in the schedule area, Your Lordship, my whole income in whatever manner I have accrued, it is exempted under Income Tax Act. Now here, Your Lordship, funny thing is that I have been served with a notice by the Income Tax Department to file income tax return for the assessment year 2017-18. Your Lordship, that notice was served under 148, and actually, Your Lordship, I am not an SEC, Your Lordship. SEC is Section 27 of Indian Income Tax Act.
Yes.
It defines SEC.
1 minute, 1 minute.
Yes, Your Lordship.
Mr. Ponas. Can you ask, I compare to bring that iPad? Yes.
Now, Section 2, subsection 7 of Indian Income Tax, it notes who is an SSC. And actually, Your Lordship, in common language, that SEC who is liable to pay tax is an SSC. I am not an SSC. Now, Section 139 of Indian Income Tax Act, it provides that an SSC has to file an income tax return if his income is within the excess of that income tax slab. Then he is liable to file, one is liable to file income tax return. But myself being a Naga, and I am exempted under Section 1026 of Indian Income Tax Act, and Your Lordship will appreciate that I have been issued, this income tax officer has issued exemption certificate under Section 1026 to me.
Yes.
And surprisingly, Your Lordship, that I have been made assessment for a huge amount.
Yes.
Then having agreed with that, I am now before this Honorable Court. Your Lordship, I beg to take Your Lordship to, they are terming me as non-filer, Your Lordship. But while I am not being an SSC, I am not a non-filer. I do not require to file an income tax return. I am not within the purview of Indian Income Tax Act to pay tax. Now, Your Lordship, there are catena of judgment of the Honorable Apex Court as well as this Honorable Court also, wherein this Honorable Court has taken decision and given verdict that these who are exempted under Section 1026, they are not liable to pay tax. But here I have been made assessment. Now, Your Lordship, I am having some catena of judgment since 1976 onwards to 2023, wherein this Honorable Court as well as the Honorable Apex Court has also held that those who are within the purview of 1026 need not require to make payment of tax. Now, Your Lordship, I beg to take Your Lordship first that page 7, para 2 of my petition, Your Lordship.
Yes.
The Hamul petition is a permanent resident of Noklak district, Noklak, Nagaland, and working for profit in the business of hardware and food grain, etc., within the territory of the state of Nagaland. The petitioner has been provided with a certificate of scheduled tribe issued on 12/11/2015, prior to that assessment year, Your Lordship, by the Additional Deputy Commissioner, Noklak. Now, Annexure 1, Your Lordship, that schedule type certificate, annexure 1, page 36, your lordship, is my schedule type certificate.
Yes.
This is to certify that Sri P. Ayang, son of such and such village, belongs to the Khiamongan Naga tribe, which is recognized as scheduled tribe under the Constitution of Nagaland Scheduled Tribe Order 1970, your lordship. So, to save the time of this honorable court, your lordship, this is my certificate. Then the next, your lordship, that pen,
Yeah, why did you take out a pen number?
pen, your lordship, that nowadays it has become necessary for everything. We require to have a pen, your lordship.
Once you have a permanent account, you file it. You should file your returns. If you're exempted,
Yes, your
you
lordship.
don't need an account number.
And now, your lordship, nowadays, your lordship, and everywhere, pen is required, even
That's a different issue.
operating a bank account, your lordship.
But once you have a permanent account number means you have an account. If you have an account, you have to file your returns.
Now, your lordship, I'm coming to that. I have given in my reply to the department, I have stated there in your lordship.
Yes.
Then, your lordship, that I have categorically stated in my plaint that, your lordship, the petitioner, para 4, page 7, your lordship,
Yes.
the petitioner does not have any business or business interest outside the local area of the residence, and particularly not outside the territory of the state of Nagaland, and is running a proprietorship business. Mine was not a partnership business, your lordship. It is a proprietorship business firm by the name of Hawan Thai and Sons, having business office at house number 106 AOMT, 2.5 mile, Dimapur, Nagaland. Now, your lordship, I am having this trade license also, your lordship. Trade license also. Now, then, your lordship, page 6, page 8, para 6, your lordship.
One. Yes.
That to show my that identity as scheduled tribe, I have been given relief also. That the petitioner has been, para 6, your lordship, the petitioner has been furnished with Form 26 AS of tax deposited source and copies of tax deducted source, certificate 26 AS for the assessment years since 2010 to 11, 2021-20 has also been furnished. It is pertinent to state and worthwhile to appreciate that the TDS certificate as and when in the relevant assessment year being necessary or required, a refund of certain amount was made and entry to that effect in Part D. Detailed paid refund of the certificate is shown. Copy of the aforesaid TDS certificate. Your lordship, that against my deposit, fixed deposit, your lordship,
Yes.
bank used to deduct tax at source. Then to get the refund, your lordship, to get that refund, I have to apply, and I have been made refund of my amount also. Being a Naga, I am not entitled to pay tax on that.
You got back the tax deducted?
Yes, TDS. For the other subsequent and previous years also, but not for that year. Now, your lordship, para 7, this is for this year. That as per 26 years, the tax deducted source for the assessment year 2017-18, a total amount of rupees 1,59,327 was deducted by the State Bank of India Dimapur branch. Be it respectfully stated that the clarification appears from the tax deducted at source certificate rises from entries of statement of financial transaction, Part E. This is bank, your lordship, bank statement, wherein repeated entries of certain amounts are also shown from and to certain back in cash as original system by SFT filer, reversal of entry by SFT filer R, and correction of error by SFT filer C. Now, your lordship, why I have narrated this, your lordship? in bank account, your lordship, that from others, entry is also being made in my account, then it is also corrected subsequently, your lordship. So this is to show that that reversal entry was also there. And after that, TDS was given. Now, your lordship.
One minute, Mr. Kohima, get me the income tax item. Yes, all right. Yes, please.
Yes, your lordship. Then, your lordship, I have been issued with a notice by the department. And basing upon that, your lordship, I filed my return for the year. For that year, I filed my return. But your lordship, wherein I have shown that my income derived from within the state of Nagaland, that is scheduled area, and I am exempted from tax. My whole income is exempted from tax. But instead, accepting that one, your lordship, without any basis, they have made an assessment against my earnings. Against my earnings, they have made an assessment, your lordship. Now, against this assessment, your lordship, that prior to that, your lordship, they have issued a show cause notice, and I have replied to that, your lordship. Annexure 10, page 66 is my show cause reply. I have narrated everything there, your lordship.
Yes, carry on.
Your lordship, this annexure 10, page 66. If your lordship kindly peruse the same, your lordship will appreciate that this I have narrated my everything in that show cause reply. And your lordship, with all fairness, I place before your lordship that being a Naga, I know that I am not liable to make any tax. So I do not maintain any books of accounts, your lordship.
Okay. Yes.
My lord. Annexure 10, page 66, your lordship.
Annexure
10, page 66.
Yes.
This is my show cause reply, your lordship, dated 29 March 2022. To the additional joint deputy, because that assessment has been done by your lordship by faceless. Nowadays, it has become a faceless assessment. Oh.
Yes.
Sorry, no. After subject, your lordship, from there, the operative portion I'm going through. The SEC is in receipt of the caption show cause notice issued by your good self, providing the SSC an opportunity to show cause why the assessment should not be completed as per the adjustment proposed in the show cause notice. In this regard, please find the SSC's response for various allegations made in the show cause notice for your kind consideration below. Now, Your Lordship, SSC has no obligation to file tax return. It is submitted as per section 139(1)(b) of the Act. A person, including an individual SSC, is required to file his tax return only if his total income during the previous years exceeds the maximum amount which is not chargeable to income tax. So this is the criteria of filing return by common us like common people, common SSC.
You take your seat. Yes.
Then, Your Lordship, furthermore, as per provision 7 to section 139(1), a person referred to in clause B, which is not required to furnish tax return under this subsection, shall file a tax return if he has deposited amount exceeding 1 crore rupees in one or more current accounts maintained with a banking company or a cooperative bank during the previous year. This provision is with effect from 1st April 2020. Your Lordship, one quote that provision, it is from affected from 1st April 2020 and not from the assessment year for which subject proceedings are in progress. Because my assessment year is 2017-18, Your Lordship. Then, Your Lordship, in the present case, as submitted earlier, as per section 1026 of the Act, the income of a member of a scheduled tribe as defined in clause 25, article 366 of the Constitution is exempt from income tax, provided he is residing in any area specified in part 1, part 2 of the table appended to paragraph 20 of the 6th schedule to the Constitution or in the state of Arunachal Pradesh, Manipur, Mizoram, Nagaland, and Tripura. Your Lordship, I'll make one clarification that this honorable court, Your Lordship, in the case of Chawan Prakash Meena, this our Gauhati honorable Gauhati High Court has even opined that Meena is from Rajasthan and he was serving in Meghalaya and he was given the tax relief, even with a direction to the department to refund his tax, whatever is this Chawan Meena case, Your Lordship. I will come later on with these rulings. Now, Your Lordship, the income accrues or arises to him from any source in such areas or states aforesaid or by way of dividend or interest. Now, interest is also, Your Lordship, and I accrued interest from a bank which is within the scheduled area of Nagaland, Dimapur. The income accrues next. In the SSC's case, both the above mentioned conditions are satisfied as discussed under. Firstly, the SSC belongs to the Kyamangon Naga tribe of Nagaland, which is a recognized scheduled tribe under the Constitution Scheduled Tribe Order 1950. Copy of SSC Scheduled Tribe Certificate with registration number 1447 and dated 12th November 2015 issued by the Office of the Additional Deputy Commissioner, Noklak, Nagaland has been again enclosed as Annexure 1. Secondly, the SSC's income during the subject year has arisen from the business activities undertaking in the state of Nagaland. The SSC is engaged in the business of trading of food grains, agricultural products, etc. under the name and style Messrs. Hawaiian, Thai and Sons. Proprietorship firm under trade license, Your Lordship, under trade license number 437/10, dated 5th February 2010, issued by the Office of the Dimapur Municipal Council.
Tell us one thing.
Yes, Your
You are
Lordship.
claiming exemption under 1026.
Yes, Your Lordship.
Take us through the section first. What does it say?
In the case of member of a scheduled tribe, as defined in clause 25 of Article 366 of the Constitution, residing in any area specified in Part 1 or Part 2 of the table appended to paragraph 20 of the 6th schedule to the Constitutions, or in the state of Arunachal Pradesh, Manipur, Mizoram, Nagaland, and Tripura, or in the areas covered by notification number TADR 3550-109 dated 23rd February 1951, issued by the Governor of Assam under the provision to subparagraph 3 of the said paragraph 20 as it stood immediately before the commencement of the Northeastern Area Reorganization Act 1971, any income which accrues or arises to him from any source in the areas or state associate or by way of dividend or interest securities.
What is an income?
My lord,
What is an income?
my income,
How do you define an income for the purposes of this provision?
now income from various sources, your lordship.
I'm not asking
Ah.
you the classification of income. I am asking you, how do you define
This
income?
income.
How do you define income? If for the purposes of section 1026.
Yes, your lordship. That it says that from any source in the areas by way of dividend or interest on securities.
See, the state, the department has raised the objection by saying that you have to disclose the sources from where you are earning
Yes.
income.
Yes, your lordship.
And for that purposes, they are making some inquiry.
Yes, your lordship.
Is that correct, Mr. Setia? Is the standing council income tax available?
Yes, yes, Lordship. In fact, my lord, what was happened, Lordship, the legal proposition is not denied, my lord. In fact, my lord, the two conditions must be fulfilled. First, my lord, the assessee, my lord, belongs to the, my lord, scheduled tribes. He has to reside within the, my lord, specified area.
There is no dispute on that.
My lord.
First proposition.
Here, my lord, the other condition that income has to be derived only from the specified area. My lord, that effect.
You pointed out from the concerned section.
Lordship, section 226, Lordship 1026 itself, Lordship, subsection A. Lordship may see section 1026, my lord.
Yes.
A. From any source in the areas. So, my lord, the source of income must be within the specified areas, Lordship. And in the present case, Lordship, in fact, though notices has been issued, my lord, and he has filed a reply, my lord, saying that, my lord, he has a business within the state of Nagaland, my lord. He has been given an opportunity to submit the, my lord, books of accounts and other relevant documents, my lord.
No. First thing is,
Lordship.
The person concerned belongs to that scheduled tribe.
Lordship.
So there is no dispute. The department is not disputing this proposition or the submission of the petitioner that he is indeed a member of a scheduled tribe.
Correct, Lordship. Yes.
If he is a member of a scheduled tribe, under 1026 he is exempted.
Lordship.
So
Subject to, my lord, subsection A, my lord.
We'll come to that.
Lordship.
He is exempted. If he is exempted, is there any necessity for that exempted person to be considered to be an assessee? He's not an assessee.
Yes, your lordship.
In fact, Lordship, that has to be determined, my lord, based on, my lord, the return filed by him, my lord.
No,
because
where's the question of the return being filed if he's exempted?
my lord, he is exempted from payment of tax if he accrues income from that particular specified area, my lord.
No, we know that, but this is a provision of a statute.
Lordship.
Right. This section 1026 does not, or any, can you show us from any particular section or rule that 1020, to get the benefit of 1026, the exempted members must file returns to satisfy that the income is from those areas?
My lord, the exemption, my lord, that has been provided by subsequent, my lord, 1026A itself, Lordship. My lord, 1026 has to be satisfied, my lord, only if his income, my lord, accrues from the specified areas only, my lord.
That is precisely what we are trying to say. 1026 gives the benefit.
My lord, my lord.
Can you show us from any provision under the act or the rules,
my lord,
as to how the benefit is accruable to a person? is there anything laid down in the procedures, in the rules, or in subsequent sections to say that to get the benefit of 1026, this is the procedure to be followed?
My lord,
Number
I have
two, if you read 1026,
my lord,
does not refer to any particular provision or procedure to be maintained to get this benefit under 1026.
my lord, what I am making my submissions is, my lord,
Yes.
that my lord, 26 itself clarifies by subsection A.
26 itself clarifies that the income can be from any source in the
My lord.
areas.
Lordship. So
That
it is
does
subject
not-
to in
that
the
does
areas.
not- No, Mr. Setia, please listen. That does not necessarily mean that that a person who is exempted under 1026 has to be treated to be an SSE and therefore is required to maintain his books of accounts or file returns.
This is the,
This is not, this cannot be read into 1026. On the other hand, perhaps the department is at liberty to make inquiries on your own. And if you find that there is any income or a part of the income which is beyond the clause A of 1026, then you can proceed to assessing. But to give burden on the person who
yes.
is otherwise exempted,
Mhm.
otherwise if he has to maintain the accounts, he has to file returns, then there must be some provision under the Act where it shows that even an exempted person has to file a return.
My lord, if his income exceeds the, my lord, threshold limit, my lord, then every person has to file a return of income, my lord.
No,
In fact,
That is not applicable to persons exempted.
only SSE, your lordship.
That is not because you see the definition of an SSE.
my lord,
Section 2(7). Section 2, subsection 7 of Indian Income Tax Act, definition of SSE.
Subsection 7.
Yes, your lordship.
You read the section? Please read.
Section
my lord, subsection 7, my lord.
subsection 7(2), subsection 7.
SSE means a person by whom any tax or any other sum of money is payable under this act and includes.
That's right. So there must be a burden
My lord.
cast by the Act on a person who is required to pay tax.
My lord.
If the Act gives you the benefit of being exempted from payment of tax, can you necessarily be also termed to be an SSE?
No.
My lord, what I am, my lord, respectfully submitting is, my lord, that exemption is not blanket exemption, my lord. It is subject to certain conditions, my lord.
No,
And
that's what we are trying to read. This section.
my lord, that condition, my lord, that will find place in subsection A of section 26.
You cannot read something which is not there in the provisions of the statute. Either you get the section amended,
yes,
or you issue circulars under CBDT, CBIT.
Yes.
Sorry, CBDT, and then you proceed accordingly. But a mere perusal of the section does not necessarily reflect that you have to be an SSE, you have to maintain. We are finding it difficult to accept this submission.
My lord, may I kindly see section 69A, lordship.
Unexplained money.
Unexplained money, my lord.
So this is also pertaining to SSE, your lordship. Everywhere the SSE is the main person. 69A, unexplained money.
69A.
Yeah, unexplained money.
Where in any financial year, the SSE is found to be the owner of any money, bullion, jewelry, or other valuable article, and such money, bullion, jewelry, or valuable article is not recorded in the books of accounts, if any.
you have to first satisfy us that exemptions, persons earning the benefit of exemptions will also necessarily be included as an SSC. You have to satisfy us on that. SSC means
My
a
lord.
person who's required to pay tax under the Act.
Lordship.
So, you see, if the department has material to show that his income is not in terms of section 1026A,
My lord.
then maybe perhaps for that particular income which has accrued at the hands of the person who's claiming exemption, you may treat him to be an SSC and direct him to take whatever steps. But if a person is otherwise exempted,
My lord.
can you still treat him to be an SSC? Because even if you look into 1026A,
Lord.
Income derived from the.
it is very clear. It is very clear that is there any section there was a section 197 or
146.
even under 197 you don't have that provision. It is for deduction of taxes at source.
Yes.
Yes, show us those judgments, what you have.
One judgment is, your lordship. That famous judgment of Northeastern N. Takim Rai versus Rambai, etc. versus Union of India.
No, all those have been considered in the full bench judgment.
Yes, yes.
All those have been referred. in the
Referred.
Full bench judgment.
Yes, probably I have not bought that on, your lordship, that Dipti Dole I am having that probably that, your lordship, this honorable court in the case of Chawan Prakash Mina has referred that one, this Pradeep Kumar Tyre, Pradeep Kumar Tyre's case, your lordship, 2010 to GLR. So to save the time of this honorable court, and I have not repeated that one. So this latest judgment, your lordship, what I have brought, this Chawan Prakash Mina has covered everything, your lordship. That 1026. And prior to that one, Dipti Dole Boshamatari NEPCO case, your lordship.
Mr. Setia,
My lord.
this Meena judgment has not been appealed against.
Lordship, it probably appeal was filed, my lord. Some other councillor engaged, my lord. I am not aware right now.
Your lordship,
My lord, in fact, lordship, the proposition laid by this the honorable court, my lord, right from my lord, the Pradeep Kumar Taye and my lord Dipti Dole Bosumatari, and even my lord in the Pradeep my lordship, the Taye case, Chandra Prakash Taye, my lord, Meena, my lord, that proposition has not been denied, my lord. Because, my lord, the scheduled tribes person residing in the specified area, my lord, and they accrued income from that particular area, my lord. Here is the case, my lord. I am relying on, my lord, my statement made in paragraph 11 and 13 of my affidavit in opposition, lordship.
Mr. Setia, just listen.
Lordship.
The Pradeep Kumar Taye and all the other judgments were on the aspect of whether a person who belongs to a scheduled tribe,
my lord,
working for gain in another area which is excluded from the scheduled tribe area,
my lord,
he will be entitled to claim the benefit.
My lord.
So therefore, the ratio laid down is that you will have to be in that particular area
Area.
to earn, to get
My
that benefit.
My lord.
Here is a case where you are insisting on the person. He claims that he is earning whatever he is earning from that area,
My lord.
and therefore is exempted under 1026.
My lord.
Whereas the department is insisting, no, the 1026 benefit is available to the person concerned only upon satisfaction of 1026 clause A.
My lord.
So these judgments do not deal with that area.
My lord. My lord.
The Pradip Kumar tie, does
Lord.
it deal with that area?
No, my lord. That only says, my lord, he has to be a resident of the specified area, my lord.
It does not say that the persons exempted are required to file periodic returns to show that this income has arisen within
My
that
lord.
year.
No, my lord. That was not dealt into, my lord.
No, not dealt, not raised.
My lord.
Therefore,
My lord, what I am submitting, my lord.
Yes.
My lord, I am relying on my statement made in, my lord, para 11 and 13 of my affidavit, my lord.
No, we understand that.
My lord.
But from which provision can you interpret that the burden is on the person claiming the benefit to continue to periodically submit that this is the requirement that they will have to show that this income is derived from that particular area. This is an interpretation you are seeking to give to 1026, but that interpretation prima facie doesn't appeal to the court unless you have some authorities to submit that this is how it is to be done, because you'll have to now define who's an SSC. If the act had clearly mentioned that beyond a particular cutoff limit, all persons are an SSC, then perhaps the position would be different.
Lord.
If it is the case that you have materials to show that the petitioner has crossed a particular limit or what do you say, the beyond the exemption limit, you have information to that extent and you are confronting the petitioner. Here is a case you're putting the burden on the petitioner who claims to be a member of a scheduled tribe, and that statement you're not denying.
Lordship.
Not your case that he does not belong to that tribe.
No. That is not the case, Lordship. In fact, my lord, we are concerned with the, my lord, non-disclosure of his income from which source, my lord.
There must be a mandate, there must be a requirement under the Act for a person exempted under 1026 to disclose the income.
Lordship.
That on a mere reading of the provision does not appear to be so.
Lordship.
Somebody does it on their own is a different issue. But it doesn't appear to be so.
May I, my lord, pray, my lord, singing, my lord, some time, my lord. Can it be on Monday, my lord? We'll go make our further research.
Yes, it can be on Monday. No problem on that. Please take us to the judgment of Meena. What does it say? What does it say? No, I'm asking the counsel for the petitioner.
My lord, this is a party to 1026, your lordship. That Meena is actually, he's from Rajasthan. Para 30, your lordship. Is page 7, para 30. Yet another reason to reject the interpretation sought to be placed on the said subsection by the revenue is the history of the subsection. It is already noticed earlier. Originally, the provision sought to exclude the employees of the government from the purview of the benefit conferred by the said subsection, which was found to be unconstitutional by the Supreme Court as certain as creating an unreasonable classification among the scheduled tribes. The Supreme Court in the case of S.K. Datta's held such a classification to be legal at para 14 of the said judgment the Supreme Court has held. It was the contention of the learned Solicitor General that exemption from income tax was given to members of certain scheduled tribes due to their economic and social backwardness. It is not possible to consider a government servant as socially or economically backward, and hence the exemption was justly denied to him. According to the Solicitor General, once a tribal becomes a government servant, he is lifted out of his social environment and assimilated into the forward section of the society, and therefore he needs no more any crutch to lean on. This argument appears to us to be wholly irrelevant. The exemption in question was not given to individuals either on the basis of their social status or economic resources. It was given to a class. Hence, individuals as individuals do not come into the picture. We fail to see in what manner the social status and economic resources of a government servant can be different from that another holding a similar position in a corporation or that of a successful medical practitioner, lawyer, architect, etc. To overpaint the picture of a government servant as the embodiment of all power and prestige should ironically today his position in the society to put it at the highest is no higher than that of others who in other walks of life have the same income. For the purpose of balanced classification, what is required is not some imaginary difference, but reasonable and substantial distinction having regard to the purpose of the law. Once it is held that such a classification of the government servants from the scope of Section 1026 is violative of Article 14 to say that a government servant or the employees of the state within the meaning of Article 12 loses the benefit on the mere accident of his being posted out of his place of origin, but within the area specified under Section 1026 and entitled to the benefit of the said section by an accident, he is posted in the same area of his origin. Such an interpretation in our view, which is dependent upon pure accident and exigencies of service, would lead to wholly arbitrary results and undesirable consequences. We therefore find no substance in the submission made by the revenue. We are of the opinion that the case of NIPCO, Tribal Employees Welfare Association, SUPRA, is wholly decided, and we approve the decision of this court, Dipti Dule, Basumatari, SUPRA, to the extent it is consistent with the present judgment. Having perused the judgment of this court rendered by a full bench in Pradeep Kumar Taire, as well as in view of the tax exemption certificate dated 10/12/2020 and 21/4/2021 issued by the respondent department, this court is of the view that the prayers made by the petitioner will have to be allowed. The petitioner is indeed entitled to the benefits accrued under Section 1026 of the Income Tax Act 1961. Accordingly, mandamus is hereby issued to the respondent, more particularly the Commissioner of Income Tax, as well as the concerned income tax officer of the ward, to expeditiously process the request for refund of income tax deducted from the salary of the petitioner and remit the petitioner forthwith. The respondent department is directed to carry out this order within a period of 3 weeks from the date of receipt of a certified copy of this order. If the department requires verification of the other document, the same may be intimated to the petitioner, who will make the same available before the respondent's authority concerned. This writ petition is accordingly allowed. Now, Your Lordship, I have not carried that along. So far, my memory goes this in this case, Chawan Prakash Meena, our this honorable court in Gauhati, probably certain order has been passed against the department to refund all the within a time frame manner. Probably it was the last decision, but I cannot remember that one. I was going through.
You find out, you bring it on Monday. We'll take it up on Monday. Are you from Kohima?
No, Your Lordship. And Your Lordship, my problem, my Lord, I am having this chronic cervical spondylitis, and actually I am under medication, but since this is a long pending case.
VC facility you were entitled?
Yes, Your Lordship.
Then when can we have it? Tuesday?
And I have already made, and I have already submitted my portion, whatever I have already. Monday I will probably see if,
No, it depends on what the.
Yes, yes, Your Lordship.
Department council says.
Yes,
Department council says it is 1026A. You
yes,
have to
Your-
satisfy that.
yes, Your Lordship.
So we'll look into it and see
Now,
what can be done.
my main point is that, Your Lordship, I'm not an SSC. And SSC is liable to file income tax
You have
return.
not shown us any material, any authority in support of your claim that who is an SSC and what is meant by the term income.
Achha.
Find out and enlighten the court.
Now, Your Lordship, my learned friend was telling that I have filed income tax return. Yes, Your Lordship, I filed income tax. I've been made to file.
That's all right. But we'll proceed again on
Yes.
Tuesday. Mr. Setia,
Lordship,
on Tuesday, we'll continue. And you, both councils, you apprise the court.
Lordship.
My lord,
Or
my lord,
issues.
my lord.
Heard your Mr.
PB Paul.
PB.
Yes, Your Lordship.
PB Paul, learned counsel, appearing for the petitioner, Mr. S. Setia, learned standing counsel, senior standing counsel, Income Tax Department, through DC, assisted by Mr. Suenzo for the court. Matter was heard at some length, further hearing to be continued on Tuesday, which is 12th. Well,
My lord, let me on Monday, Lordship.
no, Monday, I'm informed by the court master there are other matters fixed, including a division bench.
Lordship, Tuesday in Gauhati, my lord, entry tax matters are fixed, Lordship.
Then Thursday, Your Lordship.
We'll see, you engage, you find out something.
Lordship.
Matters may take place, may not take place, we don't know.
My lord, deeply obliged.
If you're engaged, you request somebody, will see how you can be accommodated.
My lord,
It's very simple. Your
Lord.
arguments, prima facie, we are not finding force.
Lordship.
Because you are trying to interpret the statute and you are not supporting your arguments with any authorities to that effect.
My lord.
So you place these authorities, we'll consider.
Lordship. I'm deeply obliged.
Yes.
Much obliged.
Obliged.
Interim is there, Your Lordship.
Interim order passed earlier, we'll continue till the next date fixed.
Much obliged.
For hearing item number 38.
Yes.
May I please, Your Lordship. Lordship, the matter pertains to appointment of the petitioner to the post of grade 4 on the basis of land ownership, Your Lordship. Lordship, in the state of Nagaland, Your Lordship, there is an existing policy where landowners are given grade 4 appointment, Lordship. So, Lordship, here the petitioner's father donated 2 bighas of land. And on that land, the PWD housing has constructed a store, Lordship. And there's a vacancy, Lordship. So the petitioner filed a representation, Your Lordship. But it has not been considered, Your Lordship. Lordship may kindly come to the memorandum, Lordship. The existing norms,
Yes.
which
Page
is at
number?
page 37, Your Lordship, Annexure D.
7.
Lordship, the relevant portion will be 3A, clause 3A. Have Lordship found, Your Lordship? Page 37.
Yes.
3A, Lordship. This is relevant
3A.
for the petitioner, Lordship, yes.
Please read.
Yes, Lordship. In other cases, prior to 26/7/2005 and subsequent to setting up of administrative and block headquarters on fully donated land where a specific written oral agreement exists providing for employment or other facility to the landowner, the claim of landowner for employment or other facility, the department concerned shall refer the matter to the Deputy Commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply order, has been given in the past. Written statements from the witnesses, that is government officials of a department concerned, district administration and village functionaries present at the time of such written oral agreement should be taken by the Deputy Commissioner. The recommendation of the Deputy Commissioner should be referred with relevant documents, explanations to the Department of Rent Revenue for examination and approval, Your Lordship. So, Lordship, the government has filed the affidavit, Lordship. The relevant annexure is at page 9, Your Lordship,
Of the
of
affidavit.
the affidavit in opposition. Page 9.
This is by respondents 1 to 4.
Yes, Your Lordship.
Yes, page 9.
Page 9. The type copy is at page 10, Your Lordship. It is more legible. I'm able to read, Your Lordship.
Land in question belongs to petitioner's father.
Yes, Your Lordship.
No appointment. Okay.
Yes, Lordship. And no,
It's an admitted.
yes, it is admitted,
fact.
Your Lordship.
Then any other, no other appointments have been made.
No other appointment is made. What's made? It's admitted fact, Your Lordship. It belongs to the petitioner.
Yes,
There is one more annexure, Lordship.
yes.
Annexure 13 of the affidavit in opposition, page 13.
Page 13.
Yes, Your Lordship.
Yes.
Here the government is saying that it could not be ascertained whether the land was donated due to lack of documentary evidence, Your Lordship.
Then
And number 2, it is, Lordship, I may be allowed to read the point number
Yes,
2, Your
yes.
Lordship. It is stated that there was no verbal or oral agreement made between the petitioner's father and the department concerned. 3, it was ascertained that the PWD store is built on the petitioner's father's land. It was ascertained from the landowners and members present during the meeting that no appointment on contractual favor was awarded to the donor's family till date, Your Lordship.
Then
So, Your Lordship, the petitioner's father, Your Lordship, donated the land, Your Lordship, on the assurance given by the district administration as well as the officials of the PWD housing that representative of the family would be given land ownership appointment, Your Lordship. This was not done, Your Lordship. I've stated in my paragraphs, also, Your Lordship. And the assurance was verbal, Your Lordship. And they're admitting that it's the store was built in the land of the
yes.
petitioners. Yes, Your Lordship.
Mr. Rangami, anything to submit?
The stand of the government is that it's not disputed that the land formerly belongs to the petitioner's father, and no contractual or other benefit has been given to the petitioner's family. But here, as my learned friend has already submitted, it could not be ascertained whether it's exactly donated or not.
No, but you see the page number 13 of your affidavit.
Yes. This,
It says that the PWD-H store, what
Yes.
does H stand for?
Housing.
Housing
yes,
is built on the petitioner's father's land.
yes,
That's
that
the-
is not disputed, Lordship.
That's not disputed.
Yes.
And there is no appointment made from the landowner's family.
No, Lord.
So
But there has to be oral or verbal agreement. And here, that also could not be
It
ascertained.
has to be deemed. Because when the land, you have, when the subdivisional officer has made a statement that the PWDH store is built on the petitioner's father's land. It has to be presumed that the land was, it has to be presumed to have been donated.
Lordship, but if that is also the case, then that the position of the petitioner is checked by clause 2 of the OM, page 37, my lord, petition of the petition. And this petition is, this of OM is notified in on 16/4/2018, Lordship.
Page number?
Page number 37 of the read petition.
37.
Yes. 37.
Yes, then,
Lordship, may I read?
yes.
All cases where administrative headquarters and block headquarters were set up in various parts of the state.
You're reading from clause?
Plus 2, Lordship, plus 2.
Clause 2,
Yes.
all cases, okay.
All cases where administrative headquarters and block headquarters were set up in various parts of the state on lands donated freely by individuals, villages, or people of that area should not be reopened for compensation or for employment or other facilities in consonance with the policy brought out by memorandum so dated 26/1997, Lord.
Then,
So in the, if so.
when was it donated?
1984.
84.
Yes, Your Lordship. And in my petition, I've stated, I have donated the land because I was given assurance that grateful appointment will be
But
given, Your
that's a
Lordship.
verbal thing.
Yes, Your Lordship, it's a verbal thing.
How do
Your
you
Lordship.
overcome clause 2? How do you overcome?
Lordship, clause 3A also is there, Your Lordship.
The land ownership in Nagaland is private, isn't it?
Yeah, Lordship.
Lands.
Lordship.
So therefore, if it is not a government land,
No.
then you have acquired it, the land must have been evolved from the person concerned or the clan.
Lordship.
So ordinarily, if you take land,
Even the initial takeover also is become very doubtful because as per under clause 3A, because it was ascertained whether it was exactly per some compensation was paid
no, maybe
or donated, that could not be ascertained, Lordship. That has become the problem.
the compensation cannot be paid, is not paid in cash, is it?
Some-
Assuming it is paid,
Some have or paid.
there must be some receipt somewhere.
That
You
is,
verify.
they say that could not be ascertained due to documentary like that.
Nevertheless, you verify from the accounts maintained by the office.
Yes. Okay.
The cash has to come from the bank account only.
Yes, that I can, that exercise I can take, but
In
very,
fact,
it is very doubtful whether we be, because in the finding itself says that could not be ascertained whether the land was donated due to lack of any documentary evidence. So I don't know whether there will be any.
No, no, you come to number 3. It was ascertained
Yes,
that this store is built on the petitioner's father's land.
that is true, Lordship.
So if it is ascertained, it is built on the father's land, so it must have been donated freely. If not for compensation. Now, if you, insofar as number 3 is concerned, it must be some, you verify whether there is any oral agreement is there.
Yes, the report says there's no, Lordship, there is no verbal or oral agreement made between the Paragraph 2 says,
No, but you see the decease order,
yes.
Yes, your lordship.
that's very clear.
Yes, your lordship.
It says that no appointment or other benefits are awarded
Yes, your lordship.
till date.
That is
Consider
not
that.
disputed.
So we dispose it off, directing you to consider the case of the petitioner within a time frame manner in terms of the office memorandum. Because that you have not, this deceased letter, you read this page number 9
Yes, your
or
lordship.
10.
It's very clear.
Yes, Lordship.
Deceased letter is very clear. It says, it has been verified. See the language used.
Yes, yes.
It has been verified that the land in question belongs to petitioner's father so-and-so, resident of such and such village. And also that no appointment or other benefits have been awarded or given to the landowner or his family members till date.
Lordship.
That's the finding of the DC. And who is to make these appointments?
Engineer in chief, Lordship.
Concerned department.
Yes, concerned.
Third, MS
Esther, your lordship.
S.
Esther.
Esther. Learned counsel appearing for the petitioner, Mr. K. Angami.
Lordship.
Learned government advocate, senior government advocate.
Lordship.
Appearing for the state. The petitioner before this court is seeking a direction to be
Post of Chokidar, your lordship, which is vacant, your lordship.
to consider the petitioner's case for appointment to a grade 4 post in terms of the OM dated so-and-so, you'll find in page 11.
16
number
for
so-and-so,
18. 16 for 18.
As per the land policy of the government. Where is the land policy?
16, page 37.
Page 37. As per the land policy. So it is submitted that the petitioner's father had donated a plot of land for to the, is it the PWD department?
Yes, your lordship. For establishment of SDO PW, yes, your lordship.
To the PWD department for establishment
Of,
of a store
yes, your lordship. Under the establishment of, yeah.
under the SDO PWD
Yes,
housing.
your lordship.
So it is submitted that on a request made by the department and the district administration, the petitioner's father, Sri Shan Yem Konyak,
Yes, your
donated the land measuring 2 bighas for the said purpose. The plot of land was taken over by the PWD department, housing, within regular housing, PWD within regular housing. In the year 1984, and thereafter, the store was constructed on the same plot of land. So it is submitted on behalf of the petitioner that in spite of several representations and requests made, representations preferred and requests made before the respective department, before the concerned authority, the prayer of the petitioner was not considered for appointment under the office under the land policy published, notified under the office memorandum number so-and-so dated 16th April 2018, page number 37. So learned counsel for the petitioner submits that this claim of the petitioner is bona fide and the department is required to actively consider the same in terms of the policy notified. So learned counsel for the petitioner has also pointed out to the affidavit filed by the respondents 1, 2, 3, and 4, referring to the affidavit filed by filed by respondents 1, 2, 3, 4. Yes. Learned Council has referred to a communication number so and so dated 7th of March 2024, page number 9 of the affidavit, to submit that pursuant to an inquiry made has referred to the communication dated so and so issued by the Deputy Commissioner Mon, Nagaland, to the Engineer in Chief, Nagaland Public Works Department, Kohima, Nagaland. So, Learned Council, the petitioner submits that as per this communication, it is mentioned that upon due verification, the land in question was found to have belonged to the petitioner's father, Sri so-and-so, who was a resident of such and such village, and also no appointment or other benefits were awarded / given to the landowner or his family till date. Stop. Learned Counsel for the petitioner therefore submits that when it is the admitted stand of the respondent department, the direction be issued to the department to consider the claim of the petitioner for appointment in a suitable post, in a grade 4 post.
Lordship, actually there is a post, Chokidar post vacant, so there's a stay not to fill up that post, Lordship. Interim order is there.
In a post available, in the post of a Chokidar, which is available, which is vacant and available, and consider the claim of the petitioner. Stop. Para. Mr. Angami, learned senior government advocate, on the other hand, disputes the claim of the petitioner. He submits that the communication dated 7th of March 2024, issued by the Deputy Commissioner, is based on the report given by the Subdivisional Officer Civil, Office of the DC Mon, and a copy of the said communication is also available. In the said affidavit, referring to the said communication also dated 7th of March 2024, he submits that it is clearly stated in the said communication that there was no verbal or oral agreement made with the petitioner's father or department, and whether the land was actually donated by the father of the petitioner could not be ascertained due to lack of any documentary evidence. Stop. He therefore submits that he further submits that in terms of the office memorandum dated so and so, it is categorically provided at clause 2 of the said office memorandum that all cases where administrative headquarters and block headquarters were set up in various parts of the state on lands donated freely by individuals or villages or people of that area should not be reopened for compensation or for employment or other facilities in consonance with the policy brought out by the memorandum number LR so and so clause 2. So he therefore submits that in the absence of any materials available with the department, it could not be ascertained whether the land was actually donated, whether the land belongs to the petitioner's father, and under such circumstances, whether the land belongs to the petitioner's father, and that apart, even if the donation was made, it was way back in 1984. And therefore, it is covered by clause 2 of the same office memorandum. And accordingly, the same should not be reopened. Stop. The petitioner therefore does not have any merit in in the petition filed, and the same should therefore be dismissed. There are learned counsels for the parties have been heard, pleadings available on record have been carefully perused. Stop. The respondents have filed their affidavits contesting the claim of the petitioner. Stop. The petitioner has a specific claim that his father donated a plot of land for construction of PWD housing store in the village of so-and-so in the district of so-and-so. Stop. That land was donated
On the assurance, Lordship.
upon an assurance received from the authorities that the petitioner, that member of his family will be given compensation,
A grade 4 appointment.
a grade 4 appointment
Yes, Lord.
in the office. So your father is still alive.
Yes, Your Lordship.
Where have you stated in the petition about that?
Lordship, I've stated in paragraph 12 of my petition.
Para 4, I think.
Yes, 4 also, 12 also.
Such submissions are supported by amendments made in para 4 and para 12 of the writ petition. Stop. The claim of the petitioner is that in terms of the land policy, since the father of the petitioner had donated a plot of land, the petitioner is entitled to an appointment in terms of the state policy. Better. The government of Nagaland by office memorandum number so-and-so dated 16th April so-and-so 2018 has notified the office memorandum. Stop. Since for the purposes of this case, the office memorandum is relevant, the same is reproduced below. Extract. Para. While clause 2 of the office memorandum reflects that all cases where administrative headquarters and block headquarters were set up on lands donated freely by individuals should not be reopened for compensation or employment. However, clause 3A specifies that in other cases prior to 26/7/2005 and subsequent to setting up of administrative and block headquarters on freely donated land, where a specific written/oral agreement exists for providing employment or other facilities, the claim of the landowner for employment or other facilities, the department shall refer the matter to the Deputy Commissioner of the district, who shall examine such claim carefully. Stop. In terms of the same provisions of the notification of office memorandum, the matter was examined by the Deputy Commissioner Mon. In his letter, in his communication to the Engineer-in-Chief, NPWD Kohima, dated 7th of March 2024, it was stated that as per the report submitted by the concerned area administrative officer, It has been verified that the land in question belongs to the petitioner's father, Sri so and so, resident of such and such village, and also that no administrative or other benefits were awarded or given to the landowner or his family members till date. Stop. But having noticed the provisions of the office memorandum dated so and so, as well as the communication issued, it is evident that pursuant to an inquiry made at the office of the, by the office of the Deputy Commissioner, it was asserted that the land was indeed donated by the petitioner's father, and on which land the PWD department has constructed a housing store, and the same still exists on the same plot of land. So it is also evident from the communication dated 7th of March 2024 that no benefit or employment whatsoever in terms of the land policy dated land policy notified by OM dated so and so, was issued or conferred on the petitioner or was conferred on the landowner's family, namely the father of the petitioner, who was the landowner. Stop. Under such circumstances, where there is a categorical finding by the Deputy Commissioner Bond that land belongs to the petitioner's father, and the PWD had constructed the PWD housing store on the said land, it is evident that the land was donated by the petitioner's family, namely his father, by the petitioner's father, namely so and so. So it is tried to mention here, tried to mention here that in Nagaland, land holdings belong to private individuals or the clans belonging to various tribes. There is very little or hardly any land holding by the government. So under such circumstances, where it is evident from the communications exchange between the Deputy Commissioner Mon and PWD that the land was land belonged to the father of the petitioner, and the PWD housing store was constructed thereon, and further that no benefit or appointment was granted to the landowner's family, namely the petitioner's father, Omar, under the provisions of the office memorandum dated so and so. The petitioner is entitled to be the landowner / landowner's family is entitled for compensation or employment, as the case may be, in terms of the said OM. Stop. As it is submitted that there is a vacant post of Chowkidar available under the concerned department, namely SDO. Where is it available?
PWD housing store, Your Lordship.
Under the under the office of the SDO PWD within bracket housing,
So, Lordship.
Chen Town,
Yes, sir.
Mon, in the district of Mon, Oman. And also, by which order is the interim order granted?
Lordship,
By earlier order,
15/12/22, Lordship.
15/12/2022, since an interim order was already issued by this court, directing the respondents not to fill up the same
Yes, sir.
place. Comma, the petitioner, the respondent authority, more particularly what is the respondent?
2 and 3, Lordship.
The respondent number 2, engineer in chief,
Yes, sir.
Nagaland Public Works. Number 3, chief engineer, PWD Housing, will take steps to pass necessary orders for appointment of the petitioner in the vacant post available. Vacant post of Chowkidar stated to be available under the SDO so and so housing, SDO PWD housing, village so and so, district Mon. Stop. The interim order passed on so and so is will continue till necessary orders are passed by the department as directed above. So writ petition is allowed in terms of the above direction. Stop. The respondents will carry out the orders as directed within a period of 8 weeks. 3 months. 3 months. He'd like to have a job before Christmas. Oh.
This is giving relief. Just this reason, I don't know.
Therefore, expedite. We'll give you two months. We carried out within 60 days from the date of receipt of a certified copy that may be served by the petitioner or through the department. Writ petition accordingly allowed in terms of the above disposed. Interim order modified to the extent indicated above. There's no IA pending. Pending IAs, if any, stand disposed of in terms of the order. Yes.
for hearing item number 41.
The issues involved in this case is, the petitioner has submitted a resignation of farm service. Before the acceptance by the authority, by the appointing authority, he has submitted a letter for withdrawal of the resignation. But without considering the petitioner's request for withdrawal of his resignation, the respondent already have released the petitioner from service. That is a grievance.
When did you submit your resignation?
Yes, sir.
First, show us your appointment order.
Appointment order is at page number 11, next one. The appointment order is 3rd February 1999. He was appointed as a primary teacher on top basis. And subsequently, on the basis of the recommendation made by the district selection board, page number 13.
Yes.
By this order, the service of the petition was regularized. This regularization order was issued on 30 March 2001.
Where is the name of the petitioner? Serial number?
Should we come to page number 14, serial number 52. Kohima. Where the petitioner, he was working on as a regular employee due to the personal family problem. The petitioner has submitted an application, the page number 19, in the type copy is page number 20. This was submitted on 31/10/2017. Here the reason cited is to do his own personal reason. I'm tendering my resignation.
Okay.
And this letter was forwarded by the respondent number 3 by letter dated 31 October 2017 to the respondent number 2. Thereafter, receipt become the page number 22.
Yes.
Received by this letter, the petitioner requested to continue service.
When was this submitted?
This was on 30/2/2021. 33.
33.
Just 33/2021.
2021.
2021.
Yes. Then
And this letter was forwarded by the respondent number 3 to respondent number 2 by letter dated page number 23.
yes.
Here it is cited. On the subject said above, I have the honor to forward from city so and so for continuation of service,
Yes.
who has tendered resignation with effect from since. So that this came in continuation of the earlier resignation. And this was issued on 6/4/2021.
Yes.
But in spite of this petitioner's request by the impugn on page number 24, not implementing this. His resignation was accepted with effect from 31/10/2017. With retrospective.
Okay.
As the lordship know that the law is settled in this issue by the big court as well as by this court. It is open to an employee to withdraw his resignation before it becomes effective.
What does the government say?
The governments are not denying the fact. Lordship, I mean, allowed to cite one judgment passed by the apex court.
No, I just want to see what is the stand of the government.
Lordship, we have stated that he submitted his resignation on 31/10/2017. And even he also admitted that he stopped performing duty for which his salary was withheld. That was an admission made in the petition. So it amounts to abandonment of his service, Your Lordship. And only after a gap of 4 years, he submitted his letter for continuation of his service. So after we have issued accepting his resignation by order dated 10/11/2022 with effect from 31/10/2017, Your Lordship. So Lordship, when he does not continue in service, the question of whether accepting his resignation with retrospective effect does not is immaterial.
No, but he sought for withdrawal prior to the order of termination.
Lordship, no, Your Lordship, but once, whether he is performing or not, if at all he is performing his duty, Your Lordship, that can be taken into consideration. But he's not
That performance of the duty, you'll have to perhaps see from because his salary was stopped, isn't
Yes,
it?
his Lordship, may come to page, his writ petition, page 5, Your Lordship. Page 5, para 5, Your Lordship. There is an admission on the part of the petitioner, page 5, para 5. Has Your Lordship got it?
Yes.
That the petitioner states that after he submitted the said resignation letter dated 31/10/2017, which was forwarded by respondent number 3 to respondent number 2, his salaries were also withheld since he stopped performing his duties. So he is no more in service, Your Lordship, from the day he resigned from the service, Your Lordship. And even if we have seen, go through the documents, Your Lordship, if there is no resignation on the part of the petitioner, how could the petitioner apply for leave engagement and GIS reporting? So it's a deemed resignation, and I have a Supreme Court judgment which is exactly the case. Exactly the facts of the present case, Your Lordship.
No, let us get the facts clear that he submitted his resignation.
Yes, Lordship.
Then on 3/3/21, he withdrew it.
Yes, Lordship.
Till the time he withdrew, was his resignation accepted by the authorities?
So, Your Lordship, in my affidavit. Your Lordship, my affidavit, I clearly stated here, why we accepted leave, because of the delay in the COVID-19 pandemic, Your Lordship. The letter of his resignation.
No, his resignation is in 17. COVID came 2 years later.
Yes, Lordship.
He
Lordship,
submitted his.
Stated here, and whether Your Lordship, if he is no more continuing in service, whether this court will be lenient enough to let him continue. Because the Supreme Court judgment is exactly the same facts, because.
We'll go into that, but let us understand the facts properly. That in 2017, when he submitted his resignation, till the time he filed his letter for withdrawal, was there any decision taken by the Education Department to terminate him?
No,
I mean,
there could
accept
have
him?
time, no. So, Your Lordship, here my submission is that when he voluntarily resigned from the post, Lordship, there is no question of accepting. A formal notice is necessary, a formal order is necessary that we are accepting
Then,
his resignation.
his papers for pension or whatever user.
Everything will be forfeited, Your Lordship, because he resigned from the post. He's not entitled. Yes.
Now, what do your rules say?
Yes.
Are there any specific rules?
Lordship,
petitioner service covered by the Nagaland Education Service Rules and. But the role is also silent with regard to the resignation.
This rule came into force in November 2017. He resigned in October 2017. So it is not applicable to him, Your Lordship.
So at that time, what rule was?
That is 2002 rule. But the petitioner is a primary teacher, Your Lordship. So so far my knowledge goes, Your Lordship, apart from the record, I think there is no service rule for the primary teacher, Your Lordship.
Do you have FRSR like that? Fundamental rule?
We follow the central.
Central, or you follow the central
Yes.
rules?
Even the central civil service pension rules we follow.
No, for it's like in state of Assam, we have the Assam FRSR. You don't have Nagaland FRSR, but is there any official notification that you will follow central FRSR?
Yes, we follow that, Your Lordship.
Is there any order to that effect?
For that, to your lordship, I need to know what that.
Okay, in the FRSR, is there any provision? There is a provision for,
Resignation, there is the provision in the central services pension rules in the disability. Should it come, I think should go 26. Service pension rules.
do you have a copy of that CCS rules?
Regarding the issue, in the present case, before the respondent accepted my resignation, I submitted a letter of withdrawal.
No, government has raised an issue that you have resigned. Now, unless you have a set of rules which says that this resignation has to be accepted, it will be presumed that you have resigned. And therefore your salary was stopped, I think.
Yes. It is open to anyone to withdraw his resignation before it became effective.
That's right. So where is your resignation letter? Again. Your resignation letter.
Resignation letter is page number 20. The type copy.
Type copy. All right, let us go to the original 19, page number 19. So in this, you say that you are resigning, you're tendering resignation from service.
From service.
So it will have to be, it will be deemed to be effective from that particular day or at least the next day after.
From the date it has become effective. That means from the date the respondent accept his resignation. From the date of his acceptance.
Where is the rule to say that it must be accepted? There must be something in the rules.
Yes. The service, since the petitioner service, till 2022, they have not accepted it. So this 2017 rules will apply.
2017 rules say what?
The rule is silent about the increase of resignation.
Then to what extent do you think it will apply?
CC's pension rules, rule 26 is the appointing authority may permit a person to withdraw his resignation in the public interest in the following condition namely. Rule 4 will be applicable. That the resignation was tendered by the government servant for some compelling reason, which did not involve any reflection on his integrity, efficiency, or conduct. In the request for withdrawal of the resignation has been made as a result of a material change in the circumstances, which originally compelled him to tender the resignation. Clause 2, that during the period intervening between the date on which the resignation became effective and the date from which the request for withdrawal was made, the conduct of the person concerned was in no way involved. Clause 3, that the period of absence from duty between the date on which the resignation became effective and the date on which the person is allowed to resume duty as a result of permission to withdraw the resignation is not more than 90 days. That the post which was vacated by the government servant on the acceptance of his resignation or any other comparable post is evident. Should this series majority is applicable in the state of Nagaland?
This is applicable.
Yes.
Is there a notification to that?
Should be just on the page. It's immediate. This applicable. This is visual.
But this is in respect of pension. Are you, how many years, what is the qualifying service for pension here?
10 years.
And how many years did he serve?
I was initially appointed on 1999. And the release order was issued with effect from 2017.
But even the moment he resigned from the service, all the service benefits are forfeited.
No, that is in the event we accept that we dismiss the petition. If we reject the petition, then of course no question of pension or anything like that. But in the event we accept his submissions, then whether pension rule will apply or not will depend on whether he's entitled to pension.
Yes.
So for that, there has to be a qualifying service, whether he has completed that qualifying service. So what is the qualifying service here? Okay. Have to be looked into it. Then, yes. Then what judgments you are referring to?
When we are to refer to 19, 17. ACC,
2019?
19, 17 ACC, page 120. Lordship, with a lengthy judgment, Lordship, I'll take your Lordship to para 11.
Yes.
In this case, several judgments passed by the ethics court on earlier occasion, as we discussed.
Okay.
Yeah, agree?
Yes, yes.
The circumstances under which an employee can withdraw the resignation tendered by him in what are the limitation to the exercise of such right have been dealt by this court in a number of cases. 11.1. And so and so, so and so. The government servant concerned was the 18th age of 35 years on 26/11/1946. He applied on 7/5/1945 for his preparatory to retirement in term of fundamental law physics. The request was initially allowed, and he was given 6 months leave, which was to expire on 25/5/1947. Then this before such expiry, on 16/5/1947, he sent an intimation that he would resume his duties, which request was rejected. The submission that the age of retirement was 60 years was rejected by this court. The submission that in terms of also of chapter 9 of the fundamental rules, he found efficient. He could have continued till he attained the age of 60 years was rejected. It was observed that when a public servant himself expresses an inability to continue his service any longer in 6, the required exercise in terms of said rules to decide whether to continue him beyond the age of 55 years was rightly not undertaken. In the age of retirement for him would be 55 years. In the context, whether you would apply for resuming duties on 16/5/1947, it was observed by the constituting bench of this court. It may be considered that it is open to a servant who has expressed to desire to retire from service. In applying to his officer to give him the requisite permission to change his mind subsequently, in asks for cancellation of the permission thus obtained, but he can be allowed to do so long as he continue in service enough after it has terminated. As we have said above, the plaintiff service ceased on so and so. The leave which was allowed to him subsequent to that death was post-retirement leave, which was granted under the special circumstances mentioned in FIR 56. He could not be held to continue his service after 26/11/1946, and consequently it was no longer competent to him to apply for joining his duties on so and so, even though the post-retirement leave had not yet run out. In our opinion, the decision of the later patent bench of the High Court
his right in his abuse.
This is not applicable to your case, this example 11.1.
Here are the big score, here we can discuss around 70 earlier decision.
I know you point out, I am just saying that in that case, he applied for preparatory leave.
It is not applicable.
Yeah, it is not applicable.
Nothing.
See, ordinarily, if you tender resignation, normally there is a rider that I would like to tender my resignation with effect from so and so date or so and so month. And prior to that particular date or prior to completion of that period, if you withdraw, then of course there are judgments in your favor. Here, the letter is very categorical that you resign, which means it has taken effect immediately, unless the rules say otherwise.
This is the next paragraph, 11.2. It's a bit similar with the issues.
Please.
In Raj Kumar versus Union of India, 11.2. An officer belonging to the Indian Administrative Service tendered resignation and increased a letter to the Chief Secretary to the Government of Rajasthan on so and so that it may be forwarded to the Government of India with remark of the state government. The state government recommended that the resignation be accepted, and on so and so, the Government of India requested the Chief Secretary to the state government to initiate the date on which the appellant was relieved of his duties, so that a formal notification could be issued in that bill. Before the date could be intimated, informal notification could be issued. The officer withdrew his resignation by letter dated so and so, so and so. On 29/3/1965, an order accepting his resignation was issued. The challenge raised by the officer was rejected in the High Court held that the resignation became effective on the date the Government of India had accepted, while dismissing the appeal, a bench of 3 judges of this court observed. In this case, the initial case was not considered, but the certain principle has been laid down by the apex court in this case. The letter written by the appellant on 21/8/1964 and 30/8/1964 did not indicate that the resignation was not to become effective until acceptance thereof was intimated to the appellant. The appellant informed the authority of the state resignation may be forwarded for early acceptance. On the plain terms of the letter, the resignation was to become effective as soon as it was accepted by the appointing authority. No rule has been framed under Article 309 of the Constitution which enact that for an order accepting the resignation to be effective, it must be communicated to the person submitting his resignation. Our intention was invited to a judgment of this court instead of so and so, so and so, so and so, in which it was held that an order of dismissal passed by an authority in keep on its file without communicating it to the officer concerned, or otherwise publishing it did not take effect as from the date on which the order was actually written out by the state authority. Such an order could not be effective after it was communicated to the officer concerned or was otherwise published. The principle of that case has no application here. Termination of employee by order passed by the government does not become effective until the order it is intimated to the employee. But where a government servant has invited by public servant has invited by his leader of resignation the termination of his employment, his services normally stands terminated from the date on which the letter of resignation is information. The letter of resignation is accepted by the appropriate authority in the absence of any law or rule governing the condition of his service to the contrary. It will not be open to the public servant to withdraw his resignation after it is accepted by the appointing authority, appropriate authority. Till the resignation is accepted by the appropriate authority in consonance with the rules governing the acceptance, the public servant concerned has locus poenitenti, but not hereafter. Until delay. Should be the remaining paragraphs is not relevant in this case.
These are all from future dates.
Yes, Lordship, after discussing the several judgment passed by on earlier occasion, Lordship, the conclusion which has been arrived by the this court in this case was, Lordship, that is in paragraph 12.
Paragraph 12.
Several judgments has been discussed, so it's a very
Yes.
lengthy paragraph. So I'm coming to paragraph 12.
Yes.
It is thus well settled that normally, until the resignation becomes effective, it is open to an employee to withdraw his resignation. Lordship, I'm relying on this.
No, that is what we are asking you from the word go. Your letter does not indicate a future date. Your letter says I'm resigning.
I'm resigning.
Means now. Unless you point out some rule to say that this resignation has to be accepted or recommended by a competent authority. And before that was done, you withdrew the resignation. All these cases which are discussed, there is a indication that I don't intend to, the language must be clear. You see, if in your letter, again, let us go back to your letters. If supposing, just for the sake of understanding the problem, supposing it would have been mentioned here that because of so-and-so personal problems, I intend to resign from my post. Or I will resign at the end of the month or beginning of next month or something like that. Then before that, you can withdraw it.
In the second paragraph.
Yes.
Therefore, I would like to request your authority to kindly accept my resignation.
But provided the rules are there, if the rules don't say anything, then whether the authority is competent to, they'll accept it and forward your papers. When were the papers forwarded, if any?
It was forwarded on the page number 21.
On 31st of
By this date also, it has been to issue the acceptance at the earliest. Page number 21, the second paragraph.
But there are no rules to that.
So unless it is accepted by the appointing authority, which my resignation will not become effective. But we are allowed to continue to the subsequent statement in this very paragraph.
Paragraph 12.
Right.
Yes.
It is thus settled, it is thus well settled that normally, until the resignation becomes effective, before it becomes effective, I submitted my letter for withdrawal. It is open to an employee to withdraw his resignation. Should I rely on this time?
Yes.
When would the resignation become effective may depend upon the governing service regulation and or the terms and condition of the office post, as stated in para so and so. In the absence of anything to the contrary, in the provision governing the terms and condition of the office post, which is very important. Or in the absence of a legal, contractual, or constitutional part, a prospective resignation can be withdrawn at any time before it becomes effective.
That is where we are stuck, because your letter does not suggest it is a prospective.
The forwarding letter speaks to accept at an early date, at an earliest.
Yes.
And I received a similar tax case. This regarding the tendering of voluntary retirement. But in here, this case also says voluntary retirement or resignation that can be withdrawn by the employee before it began effective. So maybe allowed to retire in 2005.
2000?
Well, 2005.
2012.
No, 2000.
2000.
5 SCC.
5 SCC.
621. A short judgment.
Yes.
Worship, here the facts was, he submitted an application for resignation on 18/10/1995. Worship, this is a short judgment, just short, I'm allowed to read the entire.
Yes.
Worship, I will read from Bharati. In process of the scheme for voluntary retirement, the appellant submitted an application dated 18 June 1995, seeking voluntary retirement. The offer was accepted by the respondent management by the letter dated 37/1997. If the content of the letter is not referred, so I may just allow to jump to paragraph 3.
Yes.
Since it was specifically stated in that letter that the release memo along with detailed particulars will follow. The appellant continued in service till 26/9/97, when he was relieved from the post in question. This is important. In the meantime, the appellant had already submitted a letter to the respondent on 7/8/1997, followed by another letter dated 24/9/97, withdrawing the letter dated since. Before the appointing authority accepted his resignation. In this case, also, he has submitted a letter on 7/8/1997 and 24/9/1997, withdrew his resignation, by which he had sought voluntary retirement, but this letter was not given effect to by the respondent management. The appellant then filed a writ petition in the High Court, which was dismissed by the single judge. The writ appeal filed against the judgment was dismissed by the division bench of the High Court by the impugned judgment. The High Court did not accept the condition of the appellant that he, having withdrawn the letter of voluntary retirement, would be allowed to continue his service. Chief aspect prayer which has been read in the prison. Chief, the paragraph 5 is important. From the above said facts, it would be seen that though the option of voluntary retirement exercised by the appellant by his letter dated so and so was accepted by the respondent management by the letter dated 37/1997. The appellant was not relieved from service and he was allowed to continue in service till 26/9/97, which for all practical purposes will be the effective date, as it was on this date that he was relieved from service. In the meantime, as pointed out above, the appellant had already withdrawn the offer of voluntary retirement by letter dated so and so. The question which therefore arises in this appeal is whether it is open to a person having exercised option of voluntary retirement to withdraw the said offer after its acceptance, but before it is made effective. The question is squarely answered by 3 decisions. So and so, so and so. It can be withdrawn before the effective. This being so, the question is squarely answered by 3 decisions, namely so and so, so and so, so and so, in which it was held that the resignation, in spite of its acceptance, can be withdrawn before the effective date.
Yes.
In the case also, before the respondent is appointing or already accepting by resignation, which I submitted the letter of withdrawal. So this case also is very powerful.
Okay.
That's all.
I have also pointed out the admission of the petitioner, where he stated that he resigned from service from 31/10/2017, after which he stopped
But
performing
then,
the duty.
but then your,
So he treated himself to be resigned from the service with effect from 31/10/2017, Your Worship.
but
And he
come to your department's communication at page 21.
Yes, this is the department's communication that I therefore request your authority to issue the acceptance and the earliest. But this is only the official. We have to look into the contents of the resignation letter submitted by the petitioner.
That's all right.
So
He-
the
but-
contents
but-
of the petitioner is.
No, there are there is only one issue here. In 2 different. First instance is he submits a letter giving a future date for resignation. In which case, whether prior to that particular date, whether he has filed an application for withdrawal is one issue. This is not the case here. Here he has said, I resign from so and so date. Now, whether the rules or circulars or practice requires a resignation to be accepted. And prior to acceptance, he issues the withdrawal, would be the second instance.
Okay,
He submits that it is in the second instance, it falls in the second instance. Because the communication itself issued by the subdivisional education officer to the higher authority requests for approval or acceptance,
yes.
which means that it has to be accepted. So this letter in 2000,
For that matter, I rely on this.
yes.
The text of the case is similarly to the present case. It's 2009 ACC 269. 2009 ACC 629.
1 minute, please. 2000,
2009 ACC 269.
2000 volume 9.
Yes, yeah, 9.
It's not okay.
2000 volume 9
Really?
269.
269.
It's a short judgment, so lordship, I will.
With any paragraph? No.
Yes, for paragraph 3, 4, and 5 and 6.
3 to 6.
Yes.
Okay.
Paragraph 3.
Yes.
The respondent was an employee of the Rajasthan State Electricity Board. He submitted his letter of resignation on 10/10/1983, in which it was mentioned that the resignation would be effective from 25/11/1983. The learned single judge and the division bench both have reported a finding that the respondent offered himself on duty on 22/8/1987 through his letter of even date. It was then that the board made an order dated 24/8/1987, accepting the letter of resignation with effect from 25/11/1983, exactly like in our case, and treating the respondent as relief from the foregoing of 25/11/1983. The learned single judge and the division bench of the High Court have further held that a formal letter accepting the resignation should have been issued, and since it was not done, the respondent shall be deemed to have continued in service till 22/8/1987, when he reported to resume his duties. 4. We are not inclined to subscribe to this view. The respondent tendered his resignation by his letter dated 10/10/1983, in which it was mentioned clearly that the resignation would be effective from 25/11/1983. He absented himself from duty for 4 years from the date and reported only on 22/8/1987. This conduct itself on the part of the respondent is sufficient to indicate that he treated himself to have resigned from the post which he was holding, with effect from 25/11/1983, particularly when he himself thereafter demanded payment of gratuity and other post-retirement benefits. Exactly in our case, Mr. Negotiator. Paragraph 5. Having regard to the circumstances of the case, the finding could not have been recorded by the learned single judge or the division bench that the respondent shall be deemed to be continuing in service till 22/8/1987. 6. That being so, we allow the appeal, set aside the judgment passed by the single judge and the division bench. In the particular circumstances of the case, the respondents shall be treated to have resigned from the post in question with effect from 25/11/1983. All retirement benefits as admissible under the rules shall be paid to him by the appellant oppositely within 3 months. So, Your Lordship, this judgment squarely covered the present case. Here also, after 4 years, he wants to continue. It's the race.
Now, tell me one thing. What about his, are there any benefits that you are entitled to? Nothing.
The judgment referred by my learned friend, that is the appellant is requested for his resignation with an effective date.
Yes, but
That is
here in our present case,
25/11/1983. Whereas in my case, in my application also, in my initial application also, I'm requesting to accept my resignation.
so immediately, Your Lordship, when the
So that the judgment relied on my learned friend, totally different with my case. Here he has requested for his resignation from an effective date.
from an effective
That
date,
is
and
25
after 4
11
years, the
1980.
board has accepted his
So
resignation.
in your case, the effective date is immediate.
Yes.
No, Lordship. Lordship, if you see my initial application, I'm requesting to accept,
Where is that initial application?
page 19, Lordship.
19.
I would like to request your authority to kindly accept. Only after its acceptance, it will become effective. So the fact.
But what is the rule there? Is there any rule that it needs to
Since
be
there's no
accepted?
law in us, let on by the.
So he abandoned his service and he didn't perform the duties to Lordship.
Is
His
the-
salary was stopped. So he
Is the,
abandoned it.
is the post still available, vacant?
For that matter, to your Lordship, I have to take instruction on that regard. But the question before your court is whether the acceptance, whether the order passed by the authority with retrospective effect.
Lordship, the one issue is here. If the resignation is accepted with prospective effect. That means if this is issued, if this is accepted with effect from prospective date, that is 2022. In that case, I will attain the qualifying years of 23 years. So that I'll be entitled for pension.
No. If you resign, you can.
You resign.
Resign.
Voluntary retirement is different.
You have to release me on voluntary retirement. That is.
No, it's not voluntary. When you
Once
resign.
you resign, end of the story.
It's very forbids.
But if it is a case of voluntary,
That will be another issue. That will be another issue. But now the petitioner is again willing to continue in this service.
why after 4 years? Or how many years?
After 4 years.
No, Your Lordship, the respondent, they have not acted upon my letter, my request. I've requested for now.
Did you receive any salary?
No.
Then,
But
so
Lordship,
4 years, you did not receive salary. How did you survive?
But Lordship, for the last 4 years, he also kept my application pending. It was accepted only in the year 2022, Lordship.
Whether there is an official
Yes, it is
letter, order or not, it is.
But
voluntary.
like you said, the part of the appointing of officials.
No,
latches
latches
cannot
latches is
authorize
okay,
upon
but you must first reflect on some provision to say that there is a, let us say you are writing this letter asking the authority to accept your resignation. Let us also accept that the authority has forwarded requesting for acceptance. But if there is no provision under the rules for acceptance, this letter will be deemed to be effective immediate.
But Lordship, was the judgment was by the expert.
Apex court is at a tentative date,
No, Lordship, in the product well,
at a prospective date.
a prospective resignation can be withdrawn at any time.
Correct.
It becomes effective.
Correct, prospective resignation. So prospective resignation will require maybe acceptance, maybe from a certain date.
That's why
Here, no,
in my application, I'm requesting for acceptance. In the forwarding letter.
There are-
Forwarding letters, it has requested for early acceptance.
there are some jobs where there are no rules requesting for acceptance of resignation. You look into it and tell us whether there is any provision or notification or what is the procedure? You show us the FRSR.
Should be
Central-
five-star with regard to the resignation.
Is there.
Lordship, I need to cover only by Rule 26 of the CCSP.
That is provided you are amenable to pension. You are not amenable to pension. You resign.
Lordship, in that case, I will allow the check the AFIs.
Yeah, yes. You check it and tell us. These rules are applicable only if you are eligible for pension. What is the qualifying service for pension?
Qualifying service, 10 years.
10 years. So you joined in 99.
99.
So in 2019, you become eligible.
2009.
2000,
2000, I joined in the year 1999.
1999.
So I will qualify in the year 2009.
2009. And you tendered your resignation in?
2007.
It is eligible.
No, because Lordship.
No, no,
was
no.
resigned.
No. Otherwise, you'd have been eligible.
No, for voluntary retirement, your Lordship,
20 years.
Voluntary
yes,
retirement is
for
20 years.
20 years. So your Lordship, no. It's not.
Since your worship, the issue involved is not the case of voluntary retirement. Worship, I'm only relying on the prospective resignation. Since in my application, I've requested for acceptance of a resignation. In total accepted, I submitted in 2017.
But there must be some procedure late that
Rule is silent.
rule is silent, so therefore you look into that FRSR. And if you find anything, you apprise us.
This judgment also says, paragraph 6 also says,
Hmm.
in the absence of anything to the contrary,
Yes,
in the provision governing the terms and conditions of the office of
that's right. Which paragraph?
part 12,
Paragraph 12.
2019 judgment.
Yes.
In the absence of worship, I'm reading the
Yes.
fifth paragraph, fifth line.
Hmm.
In the absence of anything to the contrary, in the provisions governing the terms and conditions of the office post, or in the absence of a legal, contractual, or constitutional part,
That's right.
a prospective resignation can be withdrawn at any time before it becomes effective.
So what is a prospective resignation?
Should by prospective, in order to show that this is the only documents which I had, and by this, by initial application, I'm requesting the accept my resignation.
How can that be interfered? There must be a.
It is upon them,
So it is a voluntary retirement.
I'm requesting them to accept.
No.
In the
Whether
year,
we
in
accept
the
it or
year
not,
2017,
Lordship for.
they accepted only in the year 2023.
So they accepted because they got scared when you do it.
It's effective from the day he wants to be resigned.
Otherwise, they're not obliged to do anything. They've not
No.
given you salary. You have not claimed for salary.
Yes.
They have not given you any pay benefits or anything like that, no pension.
After I submitted this application, my initial application, my salaries were so the question of attending the duty worship that also does not arise.
That's right. So therefore, it means that the resignation became effective then and there.
No worship, after it's became, I'm requesting for acceptance. After its acceptance, only it became effective.
Did you submit any application to the authority to say that till you accept it, pay my salary?
No worship, that is also not your worship.
But then, assuming we accept your arguments, you are entitled to salary from 2017 to 22, you'll be entitled to salary. But there was no request made by you that since my resignation is not accepted as yet, I'm deemed to be in service, pay my salary.
Without performing my activity, worship, that's not why someone purpose to claim for this.
So that is for them to worry. Why are you worried? You should be happy to get salary without performing
Worship,
duties.
this page 21 is an official letter written by the respondent number 2, the respondent number 2.
No, I agree with this 21, but this.
So this has to be, if this is acted immediately, that is another case.
That does not.
Here also is requested for acceptance at the earliest. But respondent number, official respondent number kept the matter pending.
Okay, if you want to look into the rules and come back, we can give you one more date. Otherwise, we are closing it.
Lordship, there is nothing to improve the case. So
No, no.
Lordship, may close it.
No, the rules, the FRSR, you wanted to.
There is nothing on as such in Lordship.
But you have to tell us that there is nothing by producing the rules.
I'm banking on the Supreme Court judgment because this
That's right,
judgment
but
affects. the
you are
case of
submitting that
similar
there's nothing in the FRSR, so where are the FRSRs?
If I was not being.
Tuesday, we'll take it up on Tuesday. You look through and apprise us on Tuesday. Possible? Just only for that purpose, right? Heard, learned counsels for the parties. The hearing will continue again on Tuesday, which is what date is it? 12th. 12th. Let this matter be listed again on Tuesday. An attempt will be made to dispose of the matter on that date.
For hearing item number 43.
Yes.
The issue is that the petitioner's elder brother
Yes.
was constable in the Nakalan Police, we died. Well, until there is head is from Kohima, this Chakasang area. From there, you will going to Tumukitima, that is the,
Towards Dimapur.
that is headquarter,
Yes,
Then-
then,
here in, just in the middle of the down, the vehicle met with an accident.
oh,
Who the prisoner applied. Its fact says para 14. It's a very short correction of this another.
para 14
Yes,
of the writ petition.
yes, a mixture one. 2016. Second side. The petitioner's elder brother, late second side, died in harness on 10/11/2009, who was also the sole breadwinner in the family with the untimely demise of his elder brother. The petitioner's family has great hearts. It therefore made an application for appointment on compassionate ground before the respondent number 5, that is the commandant in battalion at Nagaland, the sole prerogative of the petitioner before this court is that its application dated 5/12/2009 has not been considered by the respondent. It is also submitted that while the petitioner made the application for appointment on compassionate ground, OM dated 13/2/2002, that is the issue by was enforced, that is for compassionate appointment was enforced, therefore he is eligible for appointment and compassionate trial. The said way, the petitioner has also stated in Barat second petition that the petitioner has been pursuing his case all along. In draft, another legal notice was also served to the respondent number 4, that is the DEP Nagaland. On 4/2/2015, in therefore there is no inordinate delay or liabilities on the part of the petitioner.
So it was disposed of, directing them to consider.
My lord.
Then what happened?
Nay, what I'm trying to say,
Yes.
direction is specifically as per O.
In terms of OM.
Yes, it's a level of order is correct, strictly in terms of OM. Or
13/12.
2002.
All right, then,
Time limit was given to after studying this honorable order, it was not compliant. Then what happened? The BBC 15/17 was filed. Then page 18, indeed when the matter is called up, the learned government advocate has produced a communication data science list of any personnel who died in active service with effect from 2002 to 2016 are listed. From amongst the list of 94 persons, the name of the petitioner is late such and such is a serial document. In his year of death is indicated as 2009.
yes.
MS such and such, government advocate submitted that the list of 94 persons of compassionate appointments and made the case serial number 1 to 22 in terms of seniority in that the case of the petitioner would be considered as in this consequently in terms of the seniority as projected in communication period then 2006. In that view of the matter,
16,
both.
yes,
Then we furnish
okay.
the list we have furnished is annexure 5 serial 39 senior care.
Okay.
This is the issue in Sarah.
Okay.
11 November. This is the Indian one. That As per the assertion made in such and such, the petitioner is elder brother of the constable such and such. Two, the petitioner case does not fall within the purview of coordinated subsequently. Have ignored this honorable court correction 13 of 2002. Should be met here all
2000, what is that? OM dated 2002.
yes. That I have
That-
includes,
That OM came to be replaced by 2015.
yes.
Okay.
Where the other
And the
or
petitioner's
sister is not there.
petitioner's brother died in 2009
Yes,
during the currency of the 2002.
yes.
Okay.
So what I'm trying to say is, impure is page 23.
Yes.
As per OM 79, 2015, the appointment on compassionate grounds shall be given only to one of the following members. This is employee family, spouse, son, daughter. Through 2015, I'm out. But since from the very beginning, this honorable court correction is clear that strictly in terms of OM dated 13/02/2002. So what I'm bringing is that this should be represented.
Okay. Now, where is that 2002 notification?
Page 33.
30, 33.
Yes. Turn 9. 13 February 2000.
So it includes a brother or a sister.
Brother,
Right.
yes.
Okay. And what about the other orders? I see two more orders here in your petition. One is a contempt petition.
Well, is this.
Hmm.
I approve these for page 26. As repetition. But my learned, his lordship, Michael, only that there did not be a third proceeding. Of course, one with that is right.
So you are permitted to withdraw
Yes, in to file a
contempt.
was not the direct in, but to file a appropriate. So
So
when I approach
Hmm.
COP,
Hmm.
then his lordship, deposits, he found that no contact. So this is the repetition after all this exercise. But nothing against put the order. The only question which I relied in my affidavit in reply, similar situation arose in Rajasthan. In this, the Supreme Court also confronted with this. It was 1990 rule. When the father died in 2010, when this application was pending, 2020 came into. Then it was considered by the Supreme Court. Then it is that that's to be considered when that relevant. Who was there in that particular point of time? Particularly paragraph 5, page 10 of my activity plan. Shall I read it?
Yes.
With regard to the land council for the respective party land, we have noted that there is a conflict of view as to whether the scheme includes imposed on the date of the government servant would apply to the scheme includes imposed on the date of consideration of the application and compulsory crown would apply. There are divergent views and the conflict of opinion between decision of this board. However, keeping the same portion aside, for the reasons stated herein below, we are of the opinion that in the particular facts and circumstances of the case, the applicant herein shall be intended for appointment and compulsory crown as per 1990 rules, which were applicable at the time when the decision reside in the land. During the application for appointment under the his order that is in the year 2010. Then we are putting to the bill we para next.
Yes.
Before parting with the present order, we are constrained to observe that considering the chicken purpose of appointment and compassionate grounds. That is, family of deceased employee may be placed in a position of financial hardship under untimely termination of the employee while in service. And in the basis of policy is immediately in rendering of financial assistance to the family of the deceased, considering upon this untimely death. The authority must consider in the section of the for appointment and compulsory grounds as per the policy prevalent at the earliest but not beyond the period of 6 months from the date of commission of such completed action. We are considering to study as above. We have found that in several cases, application for appointment and compulsory grounds are not attended in time. Until 4 years later, as a result, the applicants in several cases have to approach the concerned high court seeking a writ of mandamus for the consideration of their application. Now, such direction is issued in the present case also. Direction is conditional. Tribunals of which such as reasons are given for rejecting the application. Once again, the applicant have to challenge the order of the rejection before the High Court, which leads to tendency of litigation in passage of time, leaving the family of the employee who died in a harmful lurch in financial difficulty. Persons who reason based known to the authorities in irrelevant consideration applications made for compulsory appointment are rejected after several years more are not considered. As in the instant case, it is the objective purpose of appointment and compulsory grounds as invested under the relevant policies or the laws have to be achieved, then it is just necessary that such applications are considered well in time. In the garden, we have come to cases where for nearly 2 decades, the controversy regarding the application made for compulsory appointment is resolved. This consequently leads to frustration of the police of granting compulsory appointment at the date of the following service. We therefore directed that some things must be considered and earliest point of time. Considered it must be here, reasonable, in best and deliberate consideration. Application cannot be reviewed on the basis of prevalent and for reasons extraneous to the facts of the case. And when we did the begin purpose of that,
What do the government say in their affidavit?
we are saying that this goes up to 2000.
Is there any, is the 2015 available here?
Yes, it might be. 2015 as I went out is page 24. After my name. This is included in here in given communication. That is the 11 November
Yes, okay, yes. Anything more?
It is all. In this one, I know that but to the.
Even in the contempt, the court indicated that this
Yes.
order passed was not in terms of the earlier.
Yes. Much obliged.
Yes.
Lordship, first, I would like to point out that the other dates which the commission is relying on, the commission, which make sure what? The order dated 1/6/2016 in WBC 88. This was disposed at the motion station, Lordship, and on perusal of this court order, we cannot trace whether the operating plan dated operating plan of 2015 was whether it was visited or not. There's no trace of whether it was visited on the application. And
You did not file an appeal. You did not file review. An order, if according to you did not consider certain aspects, there are means to redress this grievance. By filing a review, filing an appeal, nothing was done. You allowed this order to stand, attain finality. You see, there is no dispute that the petitioner's brother died in 2009. That is as per your list. Names included in the list, according to the department, will be considered as and when the seniority comes up. The 2002 office memorandum gives benefit to brother or sister also. 2015 restricts it to father, I think, spouse, then son and daughter. But 2015 came into effect at a later date. Does it indicate anywhere that claims which are when was a claim filed?
the OM 2002 was partially modified by OM dated. Initially, the first was modified on 16/1/2012. I don't have that copy of that OM. And thereafter.
When was the application of the petitioner filed? It was filed in 2009 itself. You can see it from page 14. So 2009 means it is under the currency of the 2002 office memorandum. So there was no requirement for perhaps the coordinate bench to examine whether 2015 is applicable, not applicable. It will be the memorandum which was prevalent at the time when the application was made will govern.
Lordship, I just know I was actually rely on one judgment.
Santosh.
Yes, Your Lordship.
Santosh.
Yes, Your Lordship.
That is in terms of the memorandum frame therein, the rules therein.
Yes. Sorry, Your Lordship.
You want to rely on this judgment that the memorandum prevalent on the date of consideration will be applicable, isn't
Yes,
it?
Your Lordship.
But this is as per the terms of that memorandum or whatever was there, subject to correction. Dealt with it. Where is that judgment?
It's in my
Reply.
Five stars.
Where is it being dealt with?
Page 8.
But how has it dealt with the judgment? It has only referred. But how has it been dealt with? No, but that is only reference.
Yes.
So and so relies on. But where has the judgment been dealt with? Referred to.
Yes. However, by the order, clearly laid out this be under balance. Otherwise, also, my lord, as your lord pointed out.
But then, if the judgment is not considered, and if it is applicable, then this judgment becomes per inquiry.
My lord, what I see is,
Yes.
as your lordship is pointed out, this honorable court direction is clear without any ambiguity that it is to be as per 13 through 2002. Which, as your lordship has pointed out, neither reviewed nor appealed. So there will be no other interpretation.
Lordship, if I will take you to the relevant document, that the judgment I was relying on.
No, see, let me make it very clear on one thing. This Santosh judgment came in the year 2020. Right? But the judgment of the coordinate bench came in 2016, directing you to consider in terms of 2002 notification. That judgment remains. It is binding on me as a coordinate bench. But that judgment has not been appealed or reviewed against. What instead you have done is, you have considered his case, because there is a very categorical finding there. You consider it in terms of so and so, 2002. You have considered it in terms of 2015. Now you have to explain why that judgment is not applicable, or why the direction has not been carried out. In your affidavit, I don't think, I have not seen any explanation as to why it is not carried out. You are considering this, his application under the 2015, because when did you pass that order? That impugned order? Where is the impugned order? Page number? No, the impugned order which is challenged here. Rejecting your claim.
Page
23. So this order was passed in 22.
Yes.
By holding that it does not fall within the purview of so and so, but you have not explained why 2002 has not been considered. Because there is a specific direction. Court's orders will have to be complied. If not complied, then you have to explain why. Either you say it's a wrong order, cannot be complied with, or there is no memorandum of 2002 or anything like that. Nothing has been done. You have simply skirted that order. So therefore, under these facts, the judgment of Santosh, in my prima facie opinion, will not be applicable because there is already an order of the court. Yes. Yes.
I will read his, my name, Your Worship.
Okay. You are the person who's supposed to consider. You have passed the impugned order. Okay.
Worship, if I may take to paragraph, with petition paragraph number 9,
Yes.
why I was arraigned as the person.
Okay.
Worship will continue.
Yes.
The direction of the respondent authority, particularly respondent 5 and 7, I'm 7, Worship, is with total malified intention, that is, one and only intent purport to defeat this honorable court's order dated 1/6/2016 and 14/3/2017. As such, it is a fit case to be punished for contempt of this honorable court's direction and order. Lordship has the contempt case has already been disposed of.
But if you look into the order of the contempt case,
Your Lordship,
para 7. Para 7 of the order,
Lordship,
there is observation that maybe the order passed in so-and-so was not in I don't know what, something was wrongly printed out. But the said aspect can be challenged in a writ court.
Lordship.
So the contempt court also accepts that the order passed.
But Lordship, this is an application under 226, Your Lordship.
Correct. Correct.
And the petitioner,
We can convert it to contempt if you want. We can convert it to contempt and.
But just by making a bold statement and weird statement, Lordship, there's nothing to show that there is malified intention.
That's okay, but fact remains that you passed that order.
Lordship,
Were you not aware of the order passed by the earlier court?
Lordship, in that regard, Lordship, I am allowed to make submission on that, Lordship.
Yes.
Lordship, in my limited knowledge and subject to your Lordship correction, I say that NC Santosh should apply, Lordship. Because when the order was passed in 2016, 2015, the scheme of 2015 was already in force. 2002 no longer exists.
But you did not appeal against or file a review against the judgment. This judgment remains.
Lordship, and even otherwise, Lordship.
Not otherwise. If there is a direction by the court, you better comply with it. Otherwise, face contempt.
Even it was not considered during the time. And even in the order in the 2017, that is a secondary petition. In the order, it has been categorically stated that to consider as per the list, the seniority list, where the petitioner is petitioner brother is at serial number 39.
I accept all your arguments, but you'll have to answer why the directions contained in the order dated this 14/3 so-and-so has not been, no, earlier to that, 16. 1/6/2016 has not been, this is an order of the court. This is an order of a coordinate bench of this court. You are entitled to, you are duty bound to explain before the court why this order is not complied with.
Lordship, when the whole scheme was in operation, it was not possible for the government also to
Then
appoint the
I do not know, then you should have sought legal advice as to how this order is to be dealt with. You cannot sit over an order with your opinion that it cannot be complied or shall not be complied with. This order should have been reviewed or an appeal should have been filed. Until that is done, from the narration in the order, there is a specific direction that you have to comply.
But with that regard, Lordship,
already contempt has been filed.
That's right. The
And
contempt court has said, that is why I pointed
only
out.
to accept the impugned order that is 2022.
No, no. You read para 7 very clearly. Para 7, the contempt court has closed this matter on the ground that the direction to consider has been complied with. Now, if the order which was passed was not in, I don't know, memorandum in question.
Memorandum in question.
Then that aspect can only be challenged by writ petition. Which means the court was conscious that this order, on the basis of which the contempt petition was closed, was passed, but not in terms of the earlier memorandum in question.
That's why, Your Lordship, the petitioner can only challenge this, the office memorandum which I have passed, Your Lordship.
No.
Not in respect to the earlier, because already a contempt case has been closed.
No. Contempt has been considered closed because they have considered. But the fact remains you did not consider in terms of the directions contained in 2002, that 2016 order. Court's orders are meant to be complied with. You must give a meaningful explanation as to why this order was never complied with. It is very clear. You see.
Because in the meantime, Lordship,
that explanation, I cannot accept it today.
because in 2021 NCC,
That explanation can be accepted only when you file a review or an appeal against that order. The order is very clear, see, strictly in terms of OM dated so and so.
As my learned friend has said that it was disposed in the motion stage.
Therefore, you come back to the same question, why no appeal, why no review? Since 2016, you passed the order, impugned order when? 2022. When is the impugned order passed?
22, Lord.
22.
Lordship, in my humble submission, Lordship, in my unlimited knowledge, in my understanding, Your Lordship, when an order has been passed by this court and after contempt proceedings has been issued, Your Lordship, I think in my limited knowledge and subject to Your Lordship correction, I think it does not exist. It's closed, Your Lordship.
That understanding has to be based on either precedents or any statute or any rules.
Because Lordship, in the para 7, it has said that maybe the order which has been passed on 5/11/2022, which I have passed,
correct,
was not in accordance with law or even not in accordance with the office memorandum,
correct,
in question.
Correct.
But the said aspect can only be challenged by way of writ petition and not by way of contempt proceedings. And Lordship, here the contempt court has not said about the order can be challenged there.
No, it has given an option. It has observed that maybe the order which was passed was not in terms of what is the meaning of that? It has accepted that this order was not passed in terms of the office memorandum 2002.
Lordship, it may not be passed.
That's right. The fact that
because it's a new cause of action, Your Lordship.
Therefore, he has filed a new writ petition. But the question of if you don't want this, we can independently decide this matter. You show us a law that on a date when it was applied, that is in 2009.
Lordship.
Why did you consider it in 22?
Lordship, because as reflected in the order of 2017, the second writ petition filed by the petitioner. The practice in Nagaland is this, Lordship, when someone died, they maintain in the department, died in harness, Lordship, they maintain the seniority list. And they are appointed strictly according to seniority list.
No. See, you understand one thing. A person has died in 2009. Your scheme in 2009 gave benefit to his relative, namely his brother. He applies. You sit over it. You don't do anything. You don't reject his application. No. Listen. Application was made on 5/12/2009. You have not decided on anything. He comes to a writ court issues an order, this
Because,
directing.
Mr. Lordship, my respectful submission, Lordship, they maintain a seniority list. So those who
Who's
die earlier, they are appointed.
Whatever,
It is
what-
reflected in the.
whatever it may be, then you'll have to accept that seniority list. He has attained a position in the seniority list.
Lordship,
Is it his fault that his name is placed at serial number 15, 16, 20, 21?
Lordship,
No.
it is also not the fault of the department that his name is in.
Exactly. It's in 39. But if you put it in a seniority list, you have accepted his claim. Otherwise, you would not have put it in a seniority list.
To consider, your Lordship.
That's right.
Consider maybe positive or negative.
No. To be included in a seniority list, he has to satisfy the parameters. Today, if he files an application under 50, will you include him in the seniority list? No.
No, whenever they apply, your Lordship, their names are included in the list, and it is not by the names seniority list, your Lordship. And I cannot bypass the other person
We are
and
not-
appoint the petitioner. your
No,
Lordship.
not that. What we are saying is where is that, let us see your memorandum, where is that seniority list included?
In the writ petition, your Lordship,
Wherever it is, writ petition or affidavit or whatever.
page 20. And the petitioner's brother in 39.
I'm not on that. Show us the rules or office memorandum or anything where it says how the names are to be considered. Where is it reflected? 2015?
No, Lordship, it is the practice that according to the date of date, the Lordship. Even the Lordship petitioner also admit that this is the practice in the state of Nagaland, your Lordship.
Yes, Mr. Counsel. What do you say?
Temptation is 74 counts in the Tatum. They are making one. That's what the count. So if this is the submission, it's another court that no option for the court after. So why? Start you're not that good.
With respect to my submission, I'm motivated to place.
Yes. Which submission?
I'm authority to place your Lordship.
Yes. Yes. What is this?
Lordship, on the ground of malafide, your Lordship. That is 1992, supply 1 SSC 222, paragraph 50 and 51.
This will consider once we decide any specific orders being passed against you.
Lordship.
You're aggrieved by the fact that you are arrayed by name as a
By
party.
name, your Lordship.
That's because you have passed the order, whatever it may be.
Malafide has been alleged, so.
Is he claiming any relief against you in person?
No, your Lordship.
Then?
But malafide
Is
has been
there,
alleged.
no, maybe, but is there any specific prayer made?
No, your Lordship.
Then? So therefore, this issue of whether malafide was there or not,
Justify that my action was in good faith.
we'll accept it. You don't need a citation for that. Yes, then?
The Lordship. I'll be relying on the Santosh as well, Lordship.
Yes.
This is Santosh and 2024 5 SCC 280.
No, show us from Santos,
Your Lordship.
what is the facts involved?
Lordship, the fact is the para number one, Your Lordship. If I may read.
Yes.
Better understanding, Your Lordship.
Yes.
Leave granted in SLP such and such and such and such. The appellants have here were the beneficiary of compassionate appointment. But on the discovery that their appointment were made divorce the provisions of the Karnataka Civil Service Appointment on Compassionate Ground Rules 1996 as amended with effect from 1/4/1999 hereinafter referred with the rules. Those appointments came to be cancelled. The amendment of the proviso to Rule 5 stipulated that in case of minor dependent of the deceased government employee, he or she must apply within 1 year from the date of death of the government servant, and he must have attained the age of 18 years on the day of making the application. Before amendment, the minor dependent was entitled to apply till 1 year of attaining majority. So Lordship, this is more or
the issue.
less same.
No,
Lordship, because before he was entitled, now he's not.
no.
Lordship.
No. This is a case for consideration of a situation, what happens when the dependent is a minor. Santosh matter is with what happens when a dependent who seeks appointment, because for getting a government servant, you have to be a major. So on a date of death, the dependent beneficiary is a minor. So he can't apply.
Lordship, the principle, Lordship,
So what is the principle?
19, para 19, Lordship.
Yes.
The text may be different, but
Yes.
I'll stick to the principle.
The
Lordship.
principle will have to be applied on the terms of the facts. You can't have a principle divorce the facts,
Lordship.
because each case is a authority for what it decides. Yes.
19.
Yes.
Applying the law governing compassionate appointment called out from the above cited judgment, our opinion on the point at issue is that the norms prevailing on the date of consideration of the application should be the basis for consideration of claim for compassionate appointment. A dependent of a government employee in the absence of a vested right curing on the death of the government employee can only demand consideration of his or her application, Your Lordship. In the Lordship, there is no vested right, Your Lordship. He is, however, entitled to seek consideration in accordance with the norms as applicable on the day of death of the government employee.
He is, however, entitled to
Seek consideration in accordance with the norms as applicable on the day of death of the government employee.
This is with regard with the peculiar facts of the case. See, you read para 19 above. In the absence of any vested right accruing, the vested right of the petitioner is accrued by virtue of a judicial order. That is what we are trying to tell you. It's not a case that he's claiming a right in 2009, which he seeks consideration in 2015 or 16. He claimed the right in 2019. He came before the court. Court disposed of the petitions, specifically directing them to consider. You did not consider it.
Because in 2015 and 16 also, even he was in the serial number 19. I could not have considered the petitioner's application in 2010 or 11 or 12.
Don't know that. There is a direction.
Because
whether the direction can be carried out or not is for you to explain before the appropriate forum.
Lordship, because the seniority is maintained, I cannot bypass.
No one is asking you to bypass.
So
But
that's why he is not. He was not considered at that point of time. And during that time, when he was in the serial number 19.
No, see.
The new scheme.
No.
Came in force.
You must understand that. Where is the second order? 2017.
2017, Your Lordship.
Right. You see, court has again closed this matter by relying on the communication dated 10/3. Right?
Lordship.
So 10/3, this order of 2017 does not modify the earlier order. That earlier order remains. This order remains. In fact, you are further directed to maintain the seniority as per 10/3.
Sure.
So how can you read that how can you read the direction that the 2002 notification will not be applicable? From which paragraph you read the direction?
Lordship, here in the second last paragraph, and that the case of the petitioner would be considered.
Correct.
So when his turn will come, so
We-
we
we-
will look
we-
into the matter whether
No,
he is
no,
eligible.
no. Which paragraph you're reading?
Lordship, Miss Levika Learner Government Council,
Yes,
page number 18, Your Lordship.
yes.
Submits that from the list of such and such, compassionate appointment have been made against serial number 1 to 2 in terms of seniority. And that the case of the petitioner would be considered as and when his turn comes strictly in terms of the seniority as
Correct,
projected.
correct. But does it alter the earlier direction? Does not. There has to be a specific direction. His term may come in 2022. But in view of this direction, you are bound to consider it unless that order is modified.
Lordship, one more citation, Your Lordship. In this regard,
This is Abhishek Kumar.
that would be the Secretary to Government
No, you're referring to 24 or something? 24 judgment?
or 24, Lordship.
Oh, it relies on Santosh Kumar.
Santosh, Lordship. That's all. That is paragraph 7. Passed by Justice Ishkesh.
Okay, then.
707.
Yes.
Lordship here. There are 13, Your Lordship. The facts is in, there are 3, Your Lordship.
Yes.
Lordship has got it.
Yes.
Admittedly, the respondent sister who was employed as assistant teacher in a government school died in harness on 8/12/2010, leaving behind her surviving her mother, 2 brothers and 2 sisters, claiming that the deceased was unmarried and the mother 2 brothers and 2 sisters were entirely dependent on her income. The respondent sought appointment on compassionate ground. The claim was rejected by the competent authority by an order dated such and such, on the ground that the amendment made to the Karnataka Civil Service appointment on compassionate ground, such and such rules 2012 on 26/12, extending the benefit of compassionate appointment to the unmarried.
Where is the ratio? Where is the ratio?
Lordship, herein, paragraph 13, the apex court has exclusively
Really, refer to the.
referred to a different judgment.
Yes.
And Your Lordship, para 18, Your Lordship. Keeping the above in mind, if we critically analyze the way in which this court has proceeded to interpret the applicability of a new scheme or modified scheme that comes into force after the death of the employee, we may notice an interesting feature. In cases where the benefit under the existing scheme was taken away or substituted with a lesser benefit,
This court directed the application of the new scheme. But in cases where the benefit under an existing scheme were enlarged by a modified scheme after the death of an employee, this court applied only the scheme that was in force on the date of death of the employee.
Yes.
And here also, Lordship. That bill was allowed, Your Lordship. And the application of respondent for compassionate appointment was dismissed, Your Lordship. Paragraph 21.
All said and done, we are troubled by the order of the single judge, coordinate bench. Are you asking the court to ignore a judicial order passed by a coordinate bench? Your submission ultimately will lead to that. Ignore that order.
Lordship, as well as the apex court order also, Lordship.
So what is the net result? That this order of the court is to be ignored
Lordship,
without giving an explanation as to why you allowed this order to attain finality. You allowed it to attain finality. There was no restriction for you to file a review or an appeal. You allowed it to become final. And you are asking the court, don't follow that order. Don't consider that order. There has to be a judicial discipline.
Question to that regard, my submission will be limited to that, Your Lordship, that the petitioner has already filed a contempt petition with regard to that order, Your Lordship, and the
See, contempt is between the court and the contemptor.
Lordship.
In a given case, the court may say, all right, we are not proceeding in contempt. That does not mean the order has become nullified. I have pointed out to you more than once at para 7, the court does not close the contempt petition on the ground that you have complied with the order. Court has closed this contempt petition on the ground that there was a direction to consider, you considered. Maybe you wrongly considered, but that is not a subject matter of contempt. You go and file a writ. Therefore, this writ has come. You cannot interpret this order of the court to say that contempt clause means it has complied with the order and that's the end of it. There is a rider to para 7. Court has observed there. That is the difference. That is why these judgments do not answer the position that you are faced with now. There is no limitation of a court's order that after 2 years it becomes redundant. Once an order is passed, it has to be complied. It has to be. Unless you explain why it cannot be complied with.
I think that would be against the principle of passed by this apex.
But then you say that, then you'd have to say that. Where has the department stated that it is against the principle or law laid down by the apex court? Nowhere. You have sit tight. If there is an order which is a wrong order, then it needs to be corrected. It is not open for me to suo moto correct that order. We cannot do it. I think you need to go through these judgments, Mr. Inti. This 21. There are several judgments referred. Just go through and come back and tell us. Santosh is against you.
There is a, this another board, I think.
No, you take the trouble to go through
Yes,
this. You
I
take the
understand
trouble to
your
go through it
lordship.
and come back again. We can continue tomorrow if you want. Tomorrow? Or next week? Tomorrow. Further hearing? Tomorrow. You go through it and find out.
No.
Go through the judgment and tell us. You also have to answer Santosh. Okay. But then you accepted the contempt order also.
I have not found it. Again.
All right. Hearing has commenced in the matter. It has remained inconclusive. Further hearing to be continued tomorrow. You note the names of all the councils. Yes. Yes.
File जो लगेगा ना कि ना file photo लो भाई ना Ada possible vision. I think